Yes.
This is well, item number 15, my lord.
15.
Though, yes, my lord. Though it has come up for hearing, my lord,
Uh-huh.
but my IA for suspension of sentence is still pending, my lord. And they are yet to file the objection.
You want to get stuck in the IA part only
My lord,
and ignore the appeal?
my lord, earlier order was like that only, my lord. Because IA is still pending. It has to be disposed of, my lord.
Item 15, you said.
Yeah.
Correct, don't forget. So what do you want?
Well, after 3 weeks, my
3
lord, in
weeks.
the meantime, if they file, my lord.
As paid for by the parties, matter stands adjourned for 3 weeks. Meantime, the state may file their objection to the IA seeking suspension of the sentence. Copy if the objection is not filed, then parties may consider. Taking up the matter for hearing, since paper book admittedly has already been prepared. List again after 3 weeks on a date to be fixed by the registrar.
Deeply obliged.
Yes.
May I please, your lordship? I am praying for listing the matter, your lord, for orders, your lordship.
What
The
matter?
criminal appeal, your lordships. IA is pending, your lordship.
IA for suspension.
Suspension, yes, your
Yes.
lordship.
What about the appeal? Paper book is ready.
Ready, your lordship.
So you
Yeah.
want to do the IA, not the appeal?
Your lordship. On 5th, your lordship, for orders.
Objection is filed or not? Not yet.
IA is already there, your lordship, with the appeal. Objection, they filed the objection, your lordship.
Okay. 5th is Friday, is it?
The accused is in jail since 18 months, your lordship. The co-accused were already acquitted.
We will have it on Monday. Okay. 8th of June.
Obliged.
Please change the date.
Your lordship, action number 13, your lordship, hearing this, your lordship. Engaged person Jed Alam is out of station today, your lordship. Kindly mathematics after 1 week.
1 week.
Yes, your lordship.
After 1 week.
And moreover, your lordship, respond number 2 service is complete, your lordship, but no one has appeared on behalf of respond number 2, lordship. As per office not dated.
Let us see the file. Then we appoint somebody. Item 30. Like X auto. X. What is flag X? Any flag X anywhere? Service report. Available there, well, like X. Yes, what does it say? Hmm. Okay. You appoint somebody then. What about this? Okay. Please write the conducting counsel, Mr. Z. Alam. No, write like this. The conducting counsel for the appellant, Mr. Z. Alam, is said to be out of station, and prayer for adjournment has been made on his behalf. Stop. It is also submitted that although notice has been served to the respondent number 2, but no one has appeared. Stop. We have perused the office note as well as the notice which was served upon the respondent number 2 with a remark. And stop. Accordingly, we accept notice to be complete upon respondent number 2. Since no one appears for respondent number 2, we appoint Srimati Ankita Bora as a legal aid counsel to represent respondent number 2 in the matter. Stop registry shall furnish her a copy of the paper book within 3 working days. List the matter for hearing after 10 days. After 10 days,
Yes,
on a date to be fixed by the registry.
and your title number 17 also, your lordship.
Oh.
Orders matter, your lordship.
17.
Yes, your lordship. Then you respondent number 2, London PPA submitted the objection, lordship, but respondent number 2 has not yet submitted the objection, your lordship. Paper book is also ready, your lordship.
Item 7.
17, your lordship.
17. 17 is what? Where? Supplementary. Hmm. Okay, we'll also appoint somebody.
The respondent number 2, your lordship, counsel is there, lordship. Actually, name is reflected.
Who is that?
D. Agarwal.
DK Agarwal.
Yes. They have not submitted their
They have not submitted their
objection, your lordship.
objection to the what? IA?
I, your lordship.
Anyone appearing for the number 2, DK Agarwal is not there.
In the
See,
morning, I've taken the consent, your lordship.
hmm?
In the morning, I called him, your lordship. He has given the consent, your lordship. He has stated that he will file the objection after 1 week, your lordship.
Okay. Conducting counsel, Mr. Z. Alam, is said to be out of station, and therefore a prayer is made for adjournment on his behalf. To stop. It is also submitted that the respondent number 2 is represented by Mr. DK Agarwala, and objection to the IA is yet to be filed by him. Stop. It is also submitted that the objection will be filed by the counsel for respondent number 2. If how much time is given?
After 1 week, your lordship.
If 1 week time is granted to him. Considering the same,
Paper book is also ready, your lordship.
list the matter. After 10 days, objection, if any, may be filed in the IA by the respondent number 2 is so advised. Stop. It is also noted that the paper book is ready. Yes.
Paper book is ready, your lordship. Paper book is ready, your lordship.
I have said that. We have noted it.
Oblige, your lordship.
Yes.
May I please, your lordship? I beg to item number 9, lordship. In this case, lordship, I have filed an IA, lordship, for suspension of sentence. Lordship, the other side, not yet filed the objection, my lord. And it should come up in the orders column.
Who's the other side?
PP, lordship. Public proceeding.
Yes.
State, my lord.
PP, what do you say?
After 2 weeks, my lord. Or 10 days, my lord.
As paid for by Mr. R. Kaushik, learned additional PP. Further 2 weeks time is granted to file objection to the IA. Ms. S. K. Nargis, learned counsel, appears for the appellant. List the matter against after 2 weeks.
In the orders column, my lord. Because of I.
IA is there, but you don't want to do the hearing. Paper book is ready, everything is ready.
Let the I be finished, my lord.
Okay, in the orders column, okay?
My lord.
Yes.
And so the listing a matrimonial appeal on Friday.
Matrimonial appeal. What is the stage?
Only for sending mediation center.
All right.
May I please, Your Honor?
Yes.
May I pay for listing of an IA, Your Worship, for orders, Your Worship? It was last listed on 18/2026, Your Worship. It is for bail, Your Worship.
Bail.
Yes, it was directed to be listed after 6 weeks.
Monday.
But
Monday.
already 12 weeks has passed.
Monday, okay?
Lord, sir.
Keep you busy.
May I please, Your Lord, sir, I beg to mention item number 7, my lord. Here
7.
in this matter, my lord, paper book is ready, but we have not received the paper book, my lord.
7 is, it's along with item
6 and
6.
7, my lord.
Lordship, I am applying
Admit.
for as a legal aid counsel in item number 6. I have received the paper.
They have
Recently, I have
recently received.
And you are for the,
Not received, my lord.
you are for the appellant?
Yes, ma'am.
In
I'm
both
for
the
that.
cases, we are for appellant. He is for 7. Item
Seven.
number 7, I
Seven.
am for item number 6.
Item 7, well, your good name?
He borrow, my lord.
Mr. D. Bora, learned counsel for the appellant in criminal appeal number 381 of 2025. Submits that although paper book is prepared, he is yet to receive a copy. So, office to furnish Mr. D. Bora copy of the paper book within 3 days. And to list these matters again, when,
Next week, any get one.
after 10 days. Well,
Obviously.
Obliged.
Please, your lordship. May it please, your lordship. I
Yes.
wish to mention item number 14 of daily list, my lord.
hmm,
Lordship, in this matter, my senior Mr. S. Mitra, who will be conducting the hearing, is having some personal difficulty today, my lord. So I'm praying for an adjournment. my lord.
Other side?
I've informed the respondent number to the informant as well as the PP, my
Hmm.
lord. PP.
When do you want it?
Item 14, my lord.
When do you want it?
Let it be listed in due course, my lord.
Due course. It's already in the hearing stage. Mr. S. Mitra, the conducting counsel for the appellants, is said to have some personal difficulty to appear before the court today. Upon a prayer made on his behalf by Mr.
AK Boro, my lord.
A.K. Boro, learned counsel, and not objected to by the other side. Matter stands adjourned to be listed again after 2 weeks on a date to be fixed by the register. Follow.
Admission item 1.
May please, your lordship.
Hmm.
Well, in this matter, the appeal is preferred against the order of maintenance
Hmm.
passed by the family court.
Hmm.
Here, both the parties are government servant. The husband is a junior assistant in a Panchayat Rural Development Department, and wife is a veterinary department, is a grade 4 employee.
Hmm.
There is a little difference of the income. So, my lord, during pendency of this revision petition,
Hmm.
there are some subsequent development. Subsequent development is that, my lord, within 15 days of the order of the stay by this honorable court,
Hmm.
the maintenance order, a domestic violence case is filed after 4.5 years. And thereafter, the husband, as per Muslim law, pronounced the talak, that is talak ahsan, in 3 months, 3 talak is given, this is valid talak. And thereafter, he filed a divorce case recently on last week. So since the TCR is already received, my lord, and the subsequent development is required to be brought in record by an additional affidavit, my lord. So this matter may be fixed on a hearing there, my lord, for a final hearing. In the meantime, I will bring on record the subsequent developments, my lord.
Have you paid the amount that you were required
But,
to pay earlier?
I have paid.
Only fact is this, the current maintenance has been step by step. I am not getting the current maintenance amount. It is correct that although I maybe have some income, but she is not escaped from the liabilities. Whether I will income something, you know, not escape. Loss of she pays 61 the husband, my lord. Pays 63 of the husband. Landed family would rightly pass the order, rightly come to a conclusion. Loss of see. Then 64 to husband was cited by the court below. Paragraph 12.
Yes, now what is the subsequent development you're saying?
Subsequent development, my lord, he has pronounced the divorce to the wife.
I am not a
And accordingly, a divorce case is filed on last week before the principal family court. And against the domestic violence case, a criminal petition is also filed before this honorable court. My lord, that is also pending. It is not in this petition, my lord.
I also submitted reply to the letter submitted by my the petition. We denied it. We denied that such type of labels will not be accepted. Otherwise, obtain the degree from the competent court of law. If the file is correct, but we will object it. Because I am still ready to maintain conjugal life. He is
I think
denying.
the
If
divorce,
divorce application is filed, petition is filed, that means you are not supposed to maintain the wife anymore.
yes, that is right, my lord.
Is it like that?
Yes, my lord, that is right. But in this petition, my lord, I think this fact is required to be brought on record. That my lord, he is pronounced a divorce and that is pending.
For maintenance, it is not necessary. If he got obtained the degree of divorce, it is well and good.
Maintenance is still being paid as of now?
My lord is pending.
It's being paid.
No,
How much? Not paid. Since when?
They are pending, they are paid,
Yeah.
but after filing of this petition, no.
Area paid.
Yes, as per direction of the first order, my lord, there is a direction for payment before he joining the service. There is a direction of the honorable court that the amount from the date of filing of the maintenance petition till her joining to the post to be paid. Accordingly, I have paid.
But other earlier to that not paid. Because of order passed by this no court. I am entitled to get maintenance from the date of filing of the petition.
Filing of the,
My lord,
From when to when have you been paid?
he paid,
let him file an
but
affidavit.
from I joined
It's not paid.
on 7/12/2000.
Let him file affidavits. And then we click here. Counsel for the petitioner submits that he would like to file an additional affidavit to bring on record the subsequent developments. Prayers allowed. Stop. Counsel for the respondent shall also file an additional affidavit indicating the material in particulars about the receipt of the maintenance from the petitioner and what amount is still due to be paid by him by the next date. This the matter again after 10 days on the date to be fixed by the registry. You would indicate what you have received, what you have to receive, okay? So that we know what is what.
Obliged.
Item 2. May I please your lordship, I have some difficulty, lordship, because on 25/2026, my name was not shown in the post list and I did not know the met appeal number also. So on that day, I was unrepresented. This case, lordship. Today I verified, lordship, case is allotted to me, but I did not know that met appeal 6 is that item because I was allotted by name of by number of IA, lordship. So some time may be granted to me. Party's name also not shown in the first list there for some difficulties and my name also not shown.
Today your name is shown.
Today so is therefore I am coming, lordship.
Oh.
But brief, I could not recognize that this brief is that.
You have the brief with you. You have the,
I just verified. Party by party's name.
how much time do you want?
1 week, lordship. Next.
Ms. R.B. Bora, Learned Counsel for the Learned Legal Aid Counsel for respondent
So
wife. Prays for a week's time to prepare the matter. Prayers allowed. List again after a week in the admission column.
obliged. 6 now.
Item 3.
This detrimental appeal, my lord,
Yes.
against the order passed by the London Principal Judge Family Court at Annex 3, my lord, page 45. Actually, on the basis of mediation report, this order has been passed without recording the satisfaction, which is mandatory under Rule 25 of the Gauhati High Court mediation rule, my lord. Civil Procedure Mediation Guwahati High Court Rules, my lord.
Hmm.
Section 20, or Rule 25, my lord.
Yes, what does it say? Rule
Rule
20.
25 is that after arriving settlement,
Hmm.
the court 7 days on receipt of the settlement, the court shall issue notice to the parties fixing day for recording the settlement. Such date not being beyond the further period of 14 days from the date of receipt of the settlement. So this recording of settlement has not been arrived at. Kindly see the order, my lord. I was absent on that day. And without notice, my lord, the order has been passed on that day that whether this mediation, the settlement has been settled or not. Ultimately, the matter has not been settled. In the mediation, it has been settled that it is restitution of legal right, my lord.
Which page are you referring to? Page number.
This 364. This
It's a different book.
different.
You were on the day when the settlement was recorded, the family could pass the order.
I was
Records that you were already heard and it was only for passing the order.
that was on that day, nothing has been heard. It will reflect from the court records only, my lord.
This is certified copy of that order. How do you know?
No, this is the order has been reflected. The respondent, Topsi, is personally present. The petitioner is absent with his steps.
Next line.
Next line, today was fixed for passing necessary order in the matter to which I have already heard the parties on the last occasion. Kindly see Rule 25, my lord.
That third part.
No, that part, even if, where is the order that there was a recording of settlement between the parties? No, nothing has been concluded by the court that there was a settlement.
Which provision you're referring?
Civil Procedure Mediation, Guwahati High Court Rules 25. Rule 25.
Rule 25.
25. Twenty-four is the settlement agreement. Then within 7 days on receipt of any settlement, the court shall issue notice to the parties fixing a date for recording the settlement. So court will have to independently record that there was a settlement. Then only order can be passed.
Let the other side appear, brother. We'll see what can be done at this stage. We'll issue notice to the other side.
My lord,
Let the other side come. We'll
Yes.
issue notice.
other side.
Heard, Mr. S.K. Ghosh,
Yeah.
learned counsel for the appellant. Who submits that by filing this appeal under section 19 of the Family Codes Act, read with section 28 of the Hindu Marriage Act 1955. The appellant has challenged the order dated 11/3/2026 passed by the Court of Principal Judge, Family Court Kachar at Silchar in FC bracket civil case number 478 of 2023, by which the learned principal judge failed to adhere to the provisions of clause 25 of Appendix 25 of the Civil Procedure Mediation bracket Gauhati High Court close bracket rules from 2007, by which the court is required to issue notice within 7 days of receipt of the settlement to the parties, fixing a date for recording the settlement. So he submits that instead of issuing such notice, the learned principal judge has proceeded to dispose of the case in terms of the mediator's settlement report. Next para in view of above, issue notice to the respondent, returnable by 3 weeks. Now, appellant to take steps for service of notice by speed post within 3 working days. List again after 3 weeks.
Item 4.
Copy this.
What is the statutory appeal, my lord? So I pray, my lord, it may kindly be admitted and the LTCR may kindly be called for, my lord.
Appeal, POCSO case. Convicted
POCSO
under,
case, my lord.
under section, under which section? Conviction,
6,
6 and sentence.
life, my lord. And 10,000 fine, my lord.
Third, Mr. Ziaul Kamal, Lanet Senior Counsel, assisted by Mr.
And P. Dev Chaudhary.
P. Ray Chaudhary for the appellant, who submits that the appellant being aggrieved with the judgment dated 23/3/2026 passed by the Court of Special Judge number 2, Golpara, Assam, in special bracket POCSO case number 32 of 2019, convicting the appellant under section 376, capital AB, IPC, and also under section 6 of the POCSO Act. And thereafter sentencing him to undergo rigorous imprisonment for life and to pay fine of rupees 10,000 with a default clause. White sentence, white order of sentence dated
Sentence
27/3/2026 has filed the instant appeal. Next panel, let the appeal be admitted. Call for the TCR. Issue notice to the state as well as to the informant public complainant. Mr. R. Kaushik, learned additional PP access notice on behalf of the state. Extra copy of the appeal memo be furnished to him. Let steps be taken for service of notice upon the respondent number 2 bracket informant as mandatorily required to the jurisdictional police station. The registry shall furnish necessary copies of the notice to the learned additional PP, who shall thereafter cause service as may be required. List again on receipt of the TCR.
for 4 weeks. That's specified. And only one thing, whether your lordship has incorporated notice to be issued on respondent to one.
Yes, I've said that.
I'll do that. Much of that.
For order cited 5.
Lordship, some timely traffic was objection file bana, no? LCR.
TCR has not come.
May please the lordship. My lord, the appeal against imprisonment for life under section 6 of POCSO Act. And record is LCR not received. So.
You'll send a
TCR
reminder.
call for my-
It is seen that the TCR has not come. Office to send a reminder to the trial court concerned to send the same immediately. List again on receipt of the TCR.
Service is complete, my lord, but none has entered into this. You've taken steps in the delay application on the other side, on the R2.
You have taken steps on whom?
Shahida Begum. The report to that effect has already been submitted, no?
It's a POCSO matter.
POCSO
But where is that
informant.
report?
Report already submitted. It is in connection of condemnation of delay application. IA criminal 335. Can you report or something?
This was in the IA. IA was for condonation.
That was disposed.
No, that was disposed, but notice had gone to respondent number 2 as per the procedure. So should another notice go in the appeal?
Lordship may not be required.
Not required as per the court's order. Already recorded. So we appoint somebody.
To your lordship.
We appoint somebody, well. Next line, before parting with the record, it is noticed that notice has already been served on respondent number 2 bracket informant, but no one has appeared. So we therefore deem it appropriate to appoint. This is Mr. or Miss Anupam. Mr. Anupam Sharma as the legal aid counsel to represent respondent number 3.
Arunakshu, Arunakshu Dhar. Serial number 7.
What is wrong with Anupam Sharma?
Hello?
What is wrong with Anupam Sharma?
I'm not hard, Lordship, nothing but your Lordship.
We are going serially. We are not choosing anybody. Serially, we are going. So, appellant shall furnish an extra copy of the appeal memo to Mr. Anupam Sharma, Learned Legal Aid Counsel for respondent number 2 within 3 working days.
We will file our objection also against I.
I is there?
For
For bail, my lord.
bail.
Where's, okay.
Appellant.
But
Appellant is in
the
jail while-
respondents may file their objection to the IA. In the meantime, if so advised. Yes.
Like,
Item 8. On board copy because
Applicant. So in filing the appeal here, there is a delay, madam. Delay of 82.
First time.
First time, madam, condonation of delay.
This delay is where, this is IA, okay.
Yes, madam.
Convictions under 302.
302, madam, it's a life
Okay. And who is respondent number 2? Informant.
informant, madam.
Is it necessary to implement the informant in 302? No, but they have made a party respondent. Nevertheless, we'll issue notice then. At Mr.
C. Chakraborty.
C. Chakraborty, Learned Counsel, for the applicant who submits that by filing this application, the applicant seeks condonation of 82 days in filing the connected appeal under section 415 oblique, not oblique, bracket 2 of the BNSS against the judgment and order dated 28/11/2025, passed by the learned additional session judge Margarita in sessions case number 210 bracket M/2015, convicting the appellant under section 302 IPC and sentencing him to undergo imprisonment. Imprisonment or simple or rigorous?
The imprisonment for life and fine of 10,000 and in
No,
default
no.
payment of
What kind of imprisonment?
simple,
Simple.
man. Page number 64.
Page number 60,
Oh, 64, madam.
sentence.
Sentence.
Okay, to undergo imprisonment for life and to pay final rupees 10,000 with a default clause. Issue notice returnable by 3 weeks. Mr. R. Kaushik, learned additional TP access letters on behalf of the state. Extra copies of the application we furnished to him. Petition applicant to take steps for service of notice upon the respondent number 2 by speed post within 3 working days. List again after 3 weeks. Respondents may file objection in the meantime, if so advised.
That's all.
Subject item 18 for orders.
May I plead your lordship?
Yes.
As per order dated 29/4/2026, appellant
What is to be done, brother?
has take the dusted. May I plead your lordship? As per order dated 29/4/2000. Yes, lordship.
Notice is refused.
Yes.
So what do we do? What to do now?
Lordship
we
deemed
go
to
ahead.
be- deemed to be served, lordship.
Huh?
Lordship deemed to be served, lordship.
Deemed to be served.
Yes, lordship.
Now, what is the next step? Records have to be called? Records received, okay.
Lordship, kindly fix the matter for hearing, Lordship.
Your good name, please?
R. Kakoti.
Ms. R. Kakuti, learned counsel for the appellant, submits that although the appellant has tried to serve notice to the respondent by way of Dasti, but the respondent has refused to accept the same. To support her submission, the learned counsel has drawn the attention of this court to the affidavit filed by the appellant, indicating the said facts. Upon perusal of the affidavit, notice is accepted to be complete upon respondent number 2. Since the records have come, that the matter be listed for what is this? Was it admitted for hearing?
Yes, Lordship.
When?
After picking.
After 2 weeks?
Yes.
After 2 weeks.
Item 19. Please, Your Lordship, this notice was issued, POXO is there.
Lordship, officer on the other side. Received a report
Hmm.
of OC Bongaigaon PS.
Somebody has to be appointed then?
Yes. Leave it to Lordships.
Please write, this is an appeal against conviction and sentence by the trial court concerned under section 376 of the IP, 76 bracket AB / 506 IPC, and also under section 6 of the POCSO Act. Notice was issued to the respondent number 2 bracket informant, and the same has been duly served, which can be seen from the report submitted by the learned additional PP, Ms. B. Bhuya. Accordingly, notice is accepted to be complete upon respondent number 2. Since no one appears for respondent number 2, we appoint Srimati Anuradha Gayan as the legal aid counsel to represent respondent number 2. This is an appeal from outside.
Lordship.
And a copy of the appeal memo be furnished to Ms. A. Gayan, learned legal aid counsel, by the appellant within 3 days from today. Further, as TCR has been duly received, office to prepare the paper book expeditiously at the cost of the appellant, and thereafter list the matter for orders once the same is ready and copies served to the parties concerned. Okay.
Item 20.
In this case, notice was issued, private respondent number 2, as well as LCR was called for, LCR received, TCR received.
TCR is received,
TCR received.
not received.
TCR not received.
Hmm.
TCR not received. TCR not received.
The Kaushik notice is served.
Regarding service report, we have not received any information yet.
The earlier order was to list it after receipt of records and report of service on respondent number 3. You made a mention. Yes. And you have not cared to find out whether they read it. What is there as well? Without making an inquiry.
Issue reminder.
What is there in your file, brother? Any indication of notice? Where's the other files? You?
Steps of. Yes, when did you take steps for service of notice?
So, my PPO is not on P.
Was it taken?
Sir, that information, I don't have.
When did you serve a copy of the PP's office?
Of course.
Huh? You have not taken steps. You have not gone through the earlier order. You have not gone through the records of the case and you have mentioned it by order.
Step, my steps are step taken, madam. Nowadays, madam, through PP office, madam, not through the receipt.
Who was through PP office?
That receipt, my lord, I have to.
Actually, the process is when they'll have to take, first they'll have to go to the registry. The registry will send to us, my lord. If they have taken the steps through registry, that note should have been there.
There's a note. There's a note from the registry saying that steps for service of notice has not been received yet in concerned section till date. That is 25/2026. So you take steps.
Lordship, my lord, there is some mistake.
Okay, it's okay. You take steps. Office note dated 25/2026 indicates that steps for service of notice has not been received by the registry. Bracket concerned section till 25/2026. Stop. Learned counsel for the appellant submits that he will take necessary steps within next 3 days. Stop. It is further noticed that although TCR was requisition, right order dated 18/2/2026, but the same has not been received yet. Top office shall therefore submit shall issue a reminder to the trial court concerned to send the TCR immediately. List the matter on receipt of the TCR.
DPO.
For hearing item 10.
Lordship, I request to take the matter for the time being as my senior is at another court.
He's on legs. What is this matter? 302. Mr. Kaushik, you are there in this case.
I have.
You are there. You are the conducting also. Any other party involved here?
Private party.
Yes.
Why not go?
So only the state as the respondent or anybody else?
Here, paper proof that appeal memo is not.
This is an appeal from jail. Isn't it?
Yes.
So appellant is represented by the amicus curiae, then you are the PP, then there's any other party? No other party?
No.
So we pass over the timing or what?
But the thing is that there
You're
is only 1 meter left. 2 meters. My little timing.
That's why I'm saying time being. I'm not adjourning it. We'll adjourn for the time being because I think this senior is on legs somewhere. Now, if it's an appeal from jail, is there any separate appeal memo preferred, drafted? Any appeal memo?
Sometimes later comes, oh shit.
Somebody from the jail drafts some appeal like that here and there. But here it seems there's nothing. Oh, there's one letter.
Yes.
Page 91.
93,
93 is also there.
91.
91 is also there.
Okay, 91, yes.
91.
I intend to prefer an appeal. That's all. And the superintendent forwards it. Paperwork is prepared. So amicus curiae is very much necessary, isn't it? To formulate what are the grounds. Okay, pass on for the time being. Well, there's no other case, so. But then there's a single bench also. So we cannot sit idle.
11 and 12.
Yeah, so much. Need some time, maybe after 2 weeks.
You're not ready today? There are two matters. You are in both cases. You are in both cases.
The first appeal, we are representing 4 of the accused persons. Subsequently, 2 other accused persons are being represented in the first appeal.
And the second one, the item.
In 259,
259, 2 sets of counsel.
okay.
For 4, appellant number 1, 4, 5, and 6, madam, we are there. And for 2 and 3, madam,
We are representing me and senior counsel.
And 255?
that madam,
F.
F.
Hawk and SKM along dear Islam. This is what, 302?
34.
Conviction for life.
Like,
I mean, sentence for life. How many witnesses are there?
in this case.
there are 8 PWs, madam, 4 DWs.
Brother is saying 11 years they are suffering in jail. Huh? 3 years only. But they were on bail.
Positive 11 years, 9 months.
They were on bail.
They were in bail, on bail during the trial, but after conviction, they were sentenced. And since conviction is stated, my lord.
2023.
23.
Okay. All right, when do you want it?
After 2 weeks, maybe.
Okay.
Nobody's on bail.
Learned counsels for the appellant submit that they require some more time to prepare the matter and pray that the matter be listed after 2 weeks for hearing. Consider the prayer. This the matter. After 2 weeks, on a date to be fixed by the registry.
Lordship, my senior is Lex for another code. It's password for the time. It's password for the timing.
This is the only case left, I think.
This is the last item.
One timing is there, and this is also timing.
16, my lord, perhaps I will also require some accommodation today, my lord.
He also requires some time.
Because the voluminous one, that copy of paper book is not with me, my lord. I will have to go to the records. If they can start, okay. True, my lord. But it's an NDPS case, so
You don't have paper book
somehow perhaps our office may have, my lord, this place.
misplaced.
Yeah.
But unless you have paper book, then very
I can-
difficult.
Record also I can do it, but say, since it is an NDPS case, my lord, some technical issues will be there, my lord.
No, you find your paper book, paper book will be required. Otherwise, how do we turn pages together?
Have you received people?
Yes, sir.
We have.
Yes.
Yeah, I can, I can take that. I can arrange my. So,
Yes. When?
Your senior is coming now.
Requiring time now.
I can supply, or they can start, or if your lordship permits, then I can reply. Also.
See, merely replying is not sufficient. You'll have to assist the court also.
Yes, ma'am, that's why I will take a copy from them today.
He does not have the paper book. So if you can provide him a
Yes,
PDF
sir.
copy and then
Yes.
let him come
But
prepared.
Lordship may kindly fix a date.
Mm.
Any day.
Next week,
That's why you're coming.
on 9th. It'll be next Tuesday, man.
What is the sentence?
Sentence is 12 years RI
Uh,
and in default and 1 lakh rupees fine and in default one year SI
Conviction under 22C.
to 22C NDPS.
What was recovered?
Yaba tablets.
What?
Yaba tablets.
Yaba.
Yeah.
What is that?
Methamphetamine.
Methamphetamine. Okay. He's right. Mr. R. Kaushik Learned, additional PP. Assam submits that somehow the paper book supplied to him has been misplaced. And he submits that if a copy is furnished to him, he'll be able to prepare the same. Prepare the matter. Considering the submission, learned counsel for the appellant shall furnish him a PDF copy of the paper book within 2 days.
Today it's a file funds.
Within 2 days, and let the matter be listed. When?
Next Tuesday, 9th.
Tuesday. What is the situation? Two weeks. They want a date also. They want a date. Huh? We'll have it on 16th. 16th. 2 weeks. Please the matter on 16th of June 2026. For hearing as paid for.
If you.
Timing 10.
Yes, madam.
It's coming.
Oh, he's coming. Okay. You're sending message. Hmm. Same thing. Yeah. Should we rise for a while? I have a cup of coffee and come. So we'll do one thing, Mr. Kaushik. We'll rise for 5 minutes and come back. Let him come.
Sorry, Your Lordship. It was in legs in port 30. This jail appeal is directed against an order of conviction under section 302 IPC, convicting the appellant and sentencing him to life imprisonment.
Where's the judgment in the paper book?
Lordship,
Judgment?
Lord,
Judgment starts from
judgment
page
starts from page 40, Your Lordship.
40.
40.
Conviction under 302.
302.
And penalties?
Life imprisonment.
Life imprisonment.
Life imprisonment. Altogether, there are 10 witnesses.
And prosecution.
Prosecution witnesses.
And defense?
Defense, no witness.
Court witness?
No court witness.
Yeah.
It is a case of denial.
Let us come to the FIR.
Lordship. Lordship will find the FIR at page number 4, Your Lordship. The FIR was lodged on 4/11/2012 after 2 days of the alleged incident. FIR is
On which date?
4/11/2012. The incident occurred on 2/11/2012 at 6:30 p.m. almost night time, Your Lordship. Because November month, 6:30 p.m. is almost night time, Your Lordship. Now, FIR Lordship will get at page number 4.
FIR is lodged by?
FIR is filed by one Ramzan Ali, who is the brother of the deceased.
Okay.
And he has specifically implicated 2 accused persons, including the present appellant.
In the FIR?
In the FIR. The appellant and his brother were directly implicated. Now, may I read the FIR, Your Lordship?
Yes.
Sir, I beg to submit that on 2/11/2012 at around 6:30 p.m., the above mentioned accused duo called my elder brother Jamaluddin to settle a domestic dispute. And when he went there, the said accused number 2 ordered and told the accused number 1 to finish off my elder brother Jamaluddin by catching hold of him. Whereupon the accused number 1 instantly hit my brother on the head with a bamboo stick, thereby knocking him down on the ground. Witness Hasmat Ali promptly took the injured to Nagaon Civil Hospital for treatment, but the doctor declared the injured dead. Be it stated here that filing of the Ejahar got delayed because of autopsy and burial of the deceased. So he has implicated 2 persons, and he has specifically said that one fatal blow was given with a bamboo stick. From the affair, it seems that both the accused were hand in glove. One caught hold of him and the other gave a...
Accused 1 and 2, they are brothers?
They are brothers, Your Lordship. But charge sheet was filed only against the present appellant, Mainul Haq. Nothing was found against the other accused, Muhammad Karamat Ali. But the way he has described it in the affair, it seems that he had tried to implicate both the brothers. But that has not been the case, Your Lordship.
So the story is that the accused persons, they called the deceased person.
Yes.
To settle some domestic dispute.
Lordship.
When he went there, one of them caught him and the other one hit him.
Lordship. With a bamboo stick.
Bamboo stick. On his head.
Yes.
One hit was enough to kill him.
From the evidence, it has come that only one blow.
One blow.
Only one.
What is the medical thing?
Medical lordship will find it.
Postmortem.
Page 77 is the
PME.
postmortem report.
Mm.
No, postmortem is at page
35.
no.
What is 25?
No, page 77, lordship. No, evidence not, sir. Lordship is asking for the report. Postmortem report. Page 77. Absolutely no other injuries except a head injury, which is reflected at page 79.
Scalp.
Skull and vertebrae.
About 12 centimeters diameter over
Right parietal bone.
parietal bone. Fractured of the right parietal bone. Bleeding from nose. Contusion present. Their opinion.
Opinion lordship will find it.
Death due to brain injury. As a result of the injury sustained.
Lordship. This is a case, lordship, I have gone through, and what I have found is that this is a case. Although it is alleged that there is a Bichar Sabha, many persons are there, but the case rests only upon the interested witnesses. And nobody has virtually witnessed the incident. Most of them are hearsay witnesses, your lordship. Now I'll take your lordship to the evidences that will depict the clear story, your lordship. Charge was framed only under section 302, and I have already said, your lordship, charge sheet was not framed against the other FIR named accused, that is Keramat Ali, the brother of the appellant hearing. Now, deposition starts from page number 9, your lordship. The first deposition is that of the informant himself, who is the brother of the deceased. And he is totally a hearsay evidence, your lordship.
Charges only under 302, isn't it?
Only under 302.
To which you denied.
Lordship.
Not guilty.
Lordship.
Okay.
Now, evidence starts.
Who is PW1?
PW1 is the informant. His name is Ramzan Ali.
Informant is the brother.
Brother. May I read you?
Yes.
I know the accused person standing on the dock. His name is Mainul Haq, the appellant hearing. He belongs to my same village. I am the informant of this case. The deceased Jamaluddin was my own brother. The occurrence took place before about 3 years, as on today. The occurrence took place at about 6:30 p.m. of the day. At the time of the occurrence, while I was returning home from the bazaar, just then I heard hue and cries coming from the house of Mainul as well as Jamaluddin, whose houses are situated adjacent to one another. Then I rushed to the house of Jamaluddin and saw my brother Jamaluddin lying on the courtyard, and many people were gathering there. Then I came to know from the family members of Jamaluddin and others gathering people that Mainul assaulted Jamaluddin with a lathi on his head. At that time, my brother has already expired and he was no more. Thereafter, he was taken to BP Civil Hospital, Nagaon, and doctor declared him as dead. Accordingly, I lodged the FIR before the police of Haibargaon in charge regarding the incident. Exhibit 1 is the FIR and Exhibit 1-1 is my signature. Police also conducted inquest over the dead body of my deceased brother Jamaluddin by Exhibit 2 inquest report, wherein is Exhibit 2-1 is my signature. So it is his case that he has heard hue and cry. Then he went and he came to know that his brother was assaulted by the appellant herein with a stick. Now, cross your lordship. Right now, I cannot remember the exact date of the incident. My brother Jamaluddin expired on the very day of occurrence. I lodged the affair in the police station after 3 or 4 days. from the date of incidents. My son-in-law Rustom Ali wrote the FIR and I was staying outside the police station. I do not know where from the FIR was written. I do not know what the contents of the FIR exhibited as Exhibit 1 was. FIR was not read over to me. The Goromari Bazaar was situated at a distance of 1 kilometer away from my home. When the deceased body was taken to hospital, I did not accompany the deceased body. He even did not go with the deceased body, Your Lordship. When I appeared at the courtyard of Jamaluddin, it was evening there and there gathered many people, but I could not recognize them due to darkness. He did not recognize any other person over there. Jalal, Hasmat Ali, Rustom Ali, Sultan Ali, Tahed Ali, and female members of Jamaluddin house informed me that the accused killed the deceased. So it is not a fact that I have not stated before the police that I came to know from the gathering people that Moinul assaulted Jamaluddin. It is not a fact that Moinul did not assault Jamaluddin on the date of occurrence. Now, what we can gather is that he did not see the incident, Your Lordship. After the incident, he went there and he came to know from some people that his brother was being hit by the appellant here. And it is a specific case that he did not accompany the deceased body when it was being taken to the hospital, Your Lordship. And he also admitted that affair was lodged after 3-4 days, Your Lordship, of the alleged incident. So at best, he is a hearsay evidence. He has heard from other end, he has narrated the facts. But what he has stated in the affair that does not tally with his evidence. He has said that both the brothers called them, one of the brother caught hold of him and the other brother had hit with a stick. That does not come at all. So FIR and his depositions, Your Lordship, there are lots of discrepancies, Your Lordship. He tried to rope in both the brothers. However, in the deposition, he did not say anything about the other brother. Now, PW2, Your Lordship.
The other brother is not an accused.
He was an FIR named accused.
Sorry?
Lordship.
Abandoned. FIR named accused.
FIR named accused. The other brother, but he did not say anything about him in the deposition.
No, he was not arrested. He was not named as an accused.
In the charge sheet also not accused. Not
the charge sheet is not.
He is not. So from the affair, it is quite a different story, Your Lordship. Affair, he says that both the brothers scolded them. One of the brother caught hold of him. Other brother asked him that you kill him. Then the other brother made a fatal blow with the stick, and then the death took place. But in this, he is saying that from the bazaar he was coming, he suddenly heard some hue and cry. He went there and found his brother in the courtyard lying, and he had heard from some people that the present appellant here in Moinul Haq, he has assaulted his brother with a stick, which resulted in the death of his brother. And he has also said that he did not accompany his brother when he was being taken to the hospital. Now, PW2, Your Lordship.
Who is PW2?
PW2 is Jalaluddin, who is the son of the deceased.
Yes, please read.
Yes. I know the accused person, namely Moinul Haq, who is absent in the court today. He belongs to my same village. The informant Ramzan Ali is my paternal uncle, and the deceased Jamaluddin was my father and younger brother of the informant. The occurrence took place before about 3 years ago from today. The occurrence took place at about 6:30 p.m. of the evening. On the date of occurrence at evening hours, a bichar was held in the house of Moinul, and my father was called on to appear in that bichar. Accordingly, my father went to the bichar in the house of accused Moinul. I also went after my father to the house of Moinul. When my father arrived at the courtyard of Moinul, he attacked my father there and assaulted on the head of my father with a lathing made of bamboo, and as a result, my father fell down on the ground. Just then I arrived at the spot. Lordship will see that after the incident, he said, just then I arrived at the spot and accused Moinul fled away therefrom. At that time, large gatherings were also there in the courtyard of Moinul. Then I lifted my father from the place of occurrence and took him to civil hospital by boarding in a tempo. He said that he took his father to the hospital. At that time, I was accompanied by Ramzan Ali, Rustam Ali, and some others while taking my father to civil hospital. On appearing at civil hospital, my father was examined by doctor, and doctor declared my father as broad dead. Thereafter, conducting post-mortem of the dead body of my father, it was handed over to us, and subsequently my uncle lodged the FIR before the police in connection with the incidents. Police asked me in connection with the case. I'll read the. So, although he said that Manul Haq assaulted, but it is his case that just after the incident he reached the spot. If Lordship sees, just then I arrived at the spot and accused Manul fled away from the spot. So after the incident, he reached the spot. He also did not see Manul fleeing away at the spot. He said that Manul fled away from the spot. And he said that he accompanied his father to the hospital. And then postmortem and all these things were done.
Cross.
Cross Lordship. The house of the accused is situated after 5 houses from my house. From my house, the distance of civil hospital is about 3 miles. The Nagaon police station is situated near the civil hospital. Just nearby the civil hospital was the Nagaon police station, but they did not give any hazard on the day. On the date of occurrence, I did not go to police to inform about the incident, and I was sleeping in my house due to death of my father. I did not state before the police in what connection Bichar was held in the house of Mainul. I arrived in the house of the accused immediately after my father arrived there. It is a fact that I have not stated before the IO that the occurrence took place at 6:30 p.m. in the evening. It is not a fact that I did not state before the IO that after assaulting my father, Mainul fled away from the place of occurrence. At the place of occurrence, I found large gathering of persons, near about 200 persons gathered at the time of occurrence. So the occurrence took place in the presence of almost 200 people. Today, I cannot exactly remember the name of the persons whom I saw in the gathering at the place of occurrence during the occurrence took place. I cannot say at present the persons who assembled in the house of Mainul for Bichar. I do not know other persons who resided in the house of Mainul. At the time of occurrence, there was slightest dark. It is not a fact that today I falsely deposed that accused Mainul assaulted on the head of my father with a bamboo lathi. It is not a fact that I did not arrive at the place of occurrence immediately after my father arrived there. The FIR was lodged by my uncle after 2 days from the date of incident. It is not a fact that the accused did not assault my father on the date of occurrence. Now, from his deposition, it is found that he followed his father, your lordship. And immediately after the incident, he reached the spot and he found that Manul had already fled away from the spot. That is, he did not see Manul at the place of occurrence. Manul already fled by the time he reached. And he also did not see the fatal assault to your lordship. That comes from the examination in chief. He said that he took his father to the hospital, but that was not there in the FIR when his uncle did not say that his son took away. In fact, he has named some other person. In the FIR, he said that one Hashmot Ali took the deceased to the hospital. Now he's saying that he also accompanied his father to the hospital.
Yes.
PW3 lordship, he is one Asmat Ali. ASMAT. While in the affair, there is a mention of one Hasmat Ali. I don't know whether he is the one and same person, but the deposition of PW3 is of one Asmat Ali. He is a villager, your lordship. He has given a new description of the incident which was not stated by the son of the deceased also.
He says he has accompanied the injured to the hospital. Perhaps he must have been the one. Asmat Ali. Spelling is Asmat. One is
Asmat Ali.
This FIR was lodged in vernacular or what?
I don't have the vernacular copy, but Lordship.
The Kaushik, just check up the FIR. Is it written in English? Asmat Ali and
Asmat Ali.
Are they not the same person? Please read the deposition in chief of number 3, PW3.
PW3. No, this is of Asmat Ali. Lordship.
So spelling could have been anything. See how Asmat Ali.
Asmat.
Asmat Ali.
Asmat. Ali.
But in PW3,
Lordship.
it's written Asmat.
He is Asmat Ali. ASMAT. Asmat Ali. I know the accused Mainul Haq, who is absent in the court today. He belongs to my village. I know the informant Ramzan Ali. He also belongs to my same village. I also know deceased Jamaluddin, who was the elder brother of informant Ramzan Ali. The occurrence took place in the year 2012 at about 6:37 p.m. At the time of occurrence, I was present in the house of the deceased Jamaluddin. He's saying that on the time of occurrence, he was in the house of the deceased. Just then, the elder brother of the accused, namely one Jalil, called on me and Jamaluddin to their house to make intervention regarding dispute occurred among their brothers. Accordingly, I, along with Jamaluddin and son of Jamaluddin, namely Jalal, went to the house of the accused person. Now, this fact was not stated by Jalaluddin that his father, along with one some Asmat Ali, they were there in the house, and then a call was made and both of them went together. He is saying that he was there in the house of Jamaluddin. Both of them were called by the accused. Then they went, and at that time, the son of the deceased also went with them. While we reached in the house of the accused Mainul, he asked us as to why we went there. Then in reply, Jamal asked Mainul as to why he was quarreling with his brothers. And then, being curious, accused Mainul gave a blow on the head of Jamaluddin with a bamboo lathi. Now, this thing has come up for the first time, Your Lordship. As a result, Jamal fell down on the ground and sustained injury on his head. Accordingly, I, along with Jalal and Rustam Ali, the son-in-law of Jamal, took injured Jamal to Nagaon Civil Hospital. He said that he, along with Jalal and Rustam Ali, another son-in-law, took the injured Jamal to the Nagaon Civil Hospital by boarding in an auto rickshaw. At civil hospital, doctor examined Jamaluddin and declared him as dead. Thereafter, police went to the hospital and did inquest on the dead body of Jamaluddin in my presence, and I put my thumb impression in the inquest report. Police examined me in connection with the case, and I gave my statement before the police. Now, from the evidence in chief, what comes out is that he was there at the house of Jamaluddin, the deceased. Both of them are present at that time. The accused called both of them. They went together, followed by the son of the deceased. But that fact was not stated by Jalaluddin, the PW2, that my father, along with Asmat Ali, they were in my house. Then call was made. Then my father and Asmat Ali went. So this fact, this is very curious, Your Lordship. This is very improbable that the son would not say that his father, along with another person, both of them were in our house. And when the call was made, my father, along with this Asmat Ali, went. He did not say anything. Jalaluddin did not say anything. He said that his father was called, his father went, and thereafter he went. But here Asmat Ali is saying that he was present with this Jamaluddin, who was the deceased. Both of them were called by the accused persons to their house, and then they went, both of them went together. This is a glaring omission made by the PW2, Your Lordship. He ought to have said that my father, along with Asmat Ali, both of them were present, both of them were called, and both of them went together. So whether he was really present there or whether he really went there or not, that is highly doubtable, Your Lordship. That fact has not been stated by PW2, Your Lordship. But PWD specifically stated that I was in the house of the Jamaluddin, that is at the house of the deceased, and both of them were called by the accused persons.
So what is there in the cross-examination?
May I read your lordship? My house is at a distance of 3 furlongs away from the house of accused Mainul. In the house of accused Mainul, I did not find Ikramul, Lalmia, Nur Islam, and Taher. The houses of the aforesaid persons are situated nearby the house of the accused Mainul. Jalil has got one son, namely Shahadat Ali, who is mentally retarded. Karamat Ali is the elder brother of Mainul Haq, and Anarul is the son of Karamat Ali. I do not know if Karamat Ali was hidden in the house of Shahadat Ali. I do not know if Mainul went to bring his son from the house of Shahadat Ali, and just then Shahadat Ali gave a blow to Mainul, for which quarrel occurred. Police recorded my statement in connection with the case after 3 days of the occurrence. It is not a fact that I have not stated before the police at the time of occurrence I was present in the house of the deceased Jamaluddin, and just then the elder brother of accused, namely one Jalil, called on me and Jamaluddin to their house to make intervention regarding dispute occurring among their brothers. It is not a fact that I did not state before the police that Jalal, the son of Jamaluddin, also went to the house of the accused Mainul along with me and Jamaluddin. It is not a fact that I did not state before the police that I and Jamaluddin together went to the house of the accused Mainul. He did not state this before the police. It is not a fact that I did not state before the police that while we reached in the house of accused Mainul, he asked us as to why we went there. Then in reply, Jamal asked Mainul as to why he was quarreling with his brothers. Jalil and Jalal used to work as laborers in my house. Now next line, Lordship will mile. No other persons went there, nor there was any meeting held there. Now he is saying that there was no any other person, there was no any bichar, nothing. No other persons went there, nor was any meeting held there. It is not a fact that Jamal is my related brother and for which I deposed falsely in connection with the case. It is not a fact that I have no personal knowledge regarding the occurrence. After saying all these things, he said that there was no bichar, there was no any other person. Specifically, no other person went there, nor there was any meeting held there. Whether in fact he had really gone to that place of occurrence or whether he had really seen the occurrence, Your Lordship, that is also quite improbable, because all other witnesses say that there was a bichar, large number of people gathered. But he said that he was there in the house of the deceased. He went to the deceased, but there was no any bichar sabha, no people was there. And there was an altercation which led to the incident. The learned court will relied on his statement heavily as a key eyewitness, Your Lordship. And I find that his presence at the place of occurrence is quite doubtful, Your Lordship. Because what is stated, the son of the deceased did not state at all that his father was accompanied by this Asmat Ali, who was there in their house. Asmat Ali said that at the time of occurrence, he was there in the house of the deceased, and both of them were together called by the accused. So they went together, Your Lordship, and the incident happened in his presence. But the son, PW2, who has deposed, he did not mention a single word about this Asmat Ali, that Asmat Ali was in fact present also about there, or that Asmat Ali accompanied his father when he went to the place of occurrence. But the learned court will relied on this evidence, Your Lordship, as a key eyewitness to the incident. PW4 is the son-in-law, Your Lordship. He also claims that he is also an eyewitness, Your Lordship, though his presence is the son-in-law of the deceased. Son-in-law? No, son-in-law of the deceased. And he is the son-in-law of the deceased. Last time. Last time you can find the they are strongly loved. son-in-law of the deceased. Last line. He said that he was also in the house of the deceased. And then hearing the hue and cry, he went from the house of the deceased and he saw the incident. But regarding his presence also, Your Lordship, PW2 did not say that my brother-in-law, Rustom Ali, was also present in the house. He did not say anything about Rustom Ali or the Asmat Ali. And both of them claimed that they were in the house and they went to the place of occurrence.
Yes.
PW4 Lordship, the son-in-law of the deceased. Here is in the cross, Your Lordship, it has come out. The last line.
Connection, paper of my father-in-law,
Right.
Deposing paper with father-in-law.
Means for the case of his father-in-law. First, well, I'll go through the positions. May I read your Lordship? I know the accused person standing in the dock. His name is Manul Haq, who is my paternal uncle-in-law. Manul Haq, the accused, is his paternal uncle-in-law. I know the informant Ramzan Ali. The deceased Jamaluddin was the elder brother of informant Ramzan Ali. The occurrence took place in the year 2012. The occurrence took place at about 6:30 p.m. in the evening. On the date of occurrence, at the time of occurrence, I was present in the house of the deceased Jamaluddin. So he's saying that he was present there in the house of. Just then, I heard somebody raising halla in the nearby house of Mainul. Then I rushed to the house of Mainul. While I reached the house of Mainul, I saw Mainul giving a blow on the head of Jamal by a bamboo lathi. On being assaulted, Jamal fell down on the ground. Jamal sustained injury on his head due to the assault of Mainul, and I saw blood oozing out from the ears, nose, and head of Jamal. At that time, many people gathered at the place of occurrence, and I and Hasmat Ali, he also said that one Hasmat Ali, took the injured Jamal to Nagaon Civil Hospital by boarding a tempo. After arriving at the hospital, doctor of BP Civil Hospital examined Jamaluddin and declared him brought dead. Police examined me in connection with the case. Now, he said that he was also in the house of the deceased. And then he went after hearing the halla.
Yes, please continue.
Lordship, cross. Cross my idea.
Incident happened in the house of the accused company. Why do-
House of that.
20-25 people were there.
Lordship.
As per cost. As per one of the, 200 people. Jalaluddin.
Lordship.
Jalaluddin says there
Yes.
were about 200 people gathered.
Lordship. And everybody in fact admitted that there was a bichar sabha. One bichar was being going on. But only this PW3 said that there was no any person. There was no any bichar sabha, only. May I read the cross?
Yes.
The cross of PW4, Your Lordship. The house of accused person is situated at a distance from my house, which is less than half mile. At the time of occurrence, besides me, there were Razia Khatun, Amaluddin, my wife Momina Khatun were present in the house of Jalaluddin. He said his wife was also there in the house of Jalaluddin and some other persons. I did not notice if all these persons went to the place of occurrence during the time of occurrence. Near the house of Mainul, there are houses of Ikramul, Lalmia, Teheruddin, Jamaluddin, etc. After 3 houses from the house of Jamal, the house of accused person is situated. I found 20-25 people at the house of Mainul when the occurrence took place, but I could not remember the name of the persons gathered there. I did not notice who rushed with me to the place of occurrence after hearing the halla. I did not notice whether Lalmia, Tahir, Ikramul went to the place of occurrence after hearing the halla. These were the nearby people, Your Lordship, but they did not go. Police examined me after 2 or 3 days of the occurrence. Later on stated that I cannot say exactly when police examined me in connection with the case, police asked me at the police station. Now, it is not a fact that I have not stated before the IO that I, along with Hasmat Ali, took the injured Jamal to the hospital by boarding a tempo. It is not a fact that I have not stated before the IO that I saw blood oozing out from the head, nose, and ears of Jamaluddin and he sustained injury on his head. It is not a fact that on the date of occurrence, accused Mainul did not assault on the head of Jamaluddin by a bamboo lathi, and I did not see the occurrence. I do not know if any quarrel occurred on the previous day in between the accused and the family of the deceased in connection with an insane boy. It is not a fact that I falsely deposed in connection with the case in favor of my father-in-law. That is also there in the improved judgment. The learned trial court felt that he is the son-in-law of the. I have gone through the. He is the son-in-law of the deceased. He said that he was there in the house of this Jamaluddin. And after the hearing hue and cry, he went there and he saw the incident. He claimed that he saw the incident. But regarding his presence, Lordship, PW2 did not say anything. That in my house, my brother-in-law was there, or this Asmat Ali was there. They also went and they also, regarding their presence, Your Lordship, nothing was said by PW2, the son of the deceased. Now, Lordship, PW5 is declared to be a hostile witness. PW6 is also a hearsay evidence. PW7 is also a hearsay evidence that they have heard. That is the case of PW5, 6, 7. I'll go through, Your Lordship. And the eye of the case was not examined because he was paralyzed at that time. Some other officer, he has deposed, Your Lordship. His evidence, Lordship, will find at least as PW10, Your Lordship. That is also important. The medical officer has clearly stated whatever they are in the post-mortem report. PW5 has been declared to be a hostile witness. He was a co-villager, Your Lordship. PW6 has evidence. He has heard it. And PW7 is also a hearsay evidence. In this case, Your Lordship, the alleged weapon that was used, that was neither seized nor recovered. That is one bamboo stick. It is clear that everybody has said it is one bamboo stick only. That has not neither been seized nor recovered. If it would have been seized and recovered, if some blood stains were there in the bamboo stick, if it would have been sent to FSL, things would have come out that bamboo stick was used as a, but the bamboo stick was not, neither is not recovered. It was not used as a piece of evidence. May I read the PW10, Your Lordship? The 10.
Who's 9?
9, he did the inquest, police officer. Inquest. And PW10, he has deposed because the IO of the case could not depose. He was indisposed of due to health issues. So 6, 7, 8 planet phone bill also did not give much importance because all these three witnesses were hairs. But still, if I'll go through your lordship, but before that PW10, your lordship.
Yes, PW10.
Yeah, PW10. On 4/11/2012, I was posted as in charge of Hybergaon town or post under Nagaon police station. On that day, I received an FIR lodged by Muhammad Ramzan Ali of village so and so. Upon receipt of the FIR, I made a GD entry by number so and so, dated so and forwarded to the Nagaon police for registration. In Exhibit 1, Exhibit 1-2 is my signature forwarding the FIR to the Nagaon police station. On the basis of the FIR, Nagaon PS case number so and so under section 109302 IPC was registered. SI Chakradhar Rai was endorsed to investigate into the case. At that time, Jagadish Kumar Sinha was the OC of the Nagaon police station. In Exhibit 1, Exhibit 1-3 is the signature of Jagadish Kumar Sinha with his endorsement. I know his signature as I worked under him. The IO of this case, namely Chakradhar Rai, was my colleague in the Hybergaon town outpost, and so I know his handwriting and signature. The investigation was performed by said Chakradhar Rai. He is paralyzed now, and so he is unable to come and depose before the court. Witness has been shown the sketch map, and he has identified the signature of Chakradhar Rai. Exhibit 3 is the sketch map, and Exhibit 3-1 is the signature of Chakradhar Rai, which I have identified. Now, the said Chakradhar Rai, during investigation of the visited the place of occurrence, drew sketch map, recorded statement of the witnesses, and collected the postmortem report. He also arrested accused Mainul Haq on 14/11/2012 and forwarded to the Honorable Court. After completion of the investigation, he submitted charge sheet against the accused Mainul Haq under section 302 IPC on so and so. Exhibit 4 is the charge sheet and 4-1 is the signature of Chakradhar Rai, which I know. It is a fact that PW5 Muhammad Lal Mia stated before Chakradhar Rai that at the time of occurrence he was present at home, and hearing hue and cry at the place of occurrence, he rushed there and saw Jalaluddin of their village lying on the ground sustaining head injury. He further stated that he heard that son of the elder uncle of accused, namely Moinuddin, son of Rahimuddin, assaulted on the head of the injured person. He heard from the village people that to call on Bichar against the accused. Jamaluddin was going to the house of the accused Moinuddin, and then accused told Jamaluddin as to what Bichar would you do, and assaulted with a lathi on the head of Jamaluddin. PW5, I have not that he was declared a hostile, your lordship, but he was a hearsay evidence. The occurrence took place on 2/11/2012 at about 6:30 p.m. according to FIR. The FIR was registered on received on 4/11/2012. The distance between the place of occurrence and the Hybergaon outpost would be about 4-5 kilometers. Chakradhar Rai went to the place of occurrence for investigation on 4/11/2012. I have not seen the extract of the GD entry on the basis of which the inquest over the dead body was conducted. It can be better said by Sashikanta Borayasai, who did the necessary formalities for conducting the inquest. PW1 Ramzan Ali did not state before the police that he could learn from the gathering that the accused Mainul assaulted Jamaluddin. This is a very important, your lordship. He did not state before the police that he had learned from the gathering that the accused Mainuddin assaulted the Jamaluddin. Now, PW2 Jalaluddin, that is the son, did not state before the police that a village bechar was held and the accused fled away after assaulting his father. PW3 Asmat Ali did not state before the police that he was present at the house of Jamaluddin at the time of occurrence. An elder brother of accused as well as the accused called them to the place of occurrence. The son of Jamaluddin accompanied him to the house of the accused. When they reached, Jamaluddin asked the accused as to why he had quarreled with his brothers. These facts were not stated before the police, your lordship. For the first time in the evidence, lordship, it has come up. PW4 Rustam Ali did not state before the police that he, along with Hasmat Ali, took the injured to the hospital in a tempo and the injured was bleeding from the head, nose, and ear. It is not a fact that Chakradhar Rai did not conduct the investigation properly as per rules.
So total 10.
All total 10, your lordship. From the full narration, your lordship. Lordship.
Yeah.
What it transpires is that nobody, PW1, the informant, he did not see the incident. He has admitted it. Now, PW2, the son, he said that he accompanied his father. His father went, he followed him. And when just after the incident, he reached the spot. And by that time, the accused Manul had also fled away. So he did not see Manul in the place of occurrence. And he also did not see the fatal assault that is being made. This is in the examination chief, that is what I am saying, your lordship. Then PW3, your lordship, Asmat Ali, he gave somehow a new description that he was in the house of the deceased, your lordship. He went there along with the deceased. Both of them were together called by the accused. They went there together. And then he saw the incident. But your lordship, regarding his presence, your lordship, PW2 did not say anything. This is very important, your lordship, because he is the son of the deceased. And PW3 is saying that I was present in the house of Jamaluddin, and I, along with Jamaluddin, went to the house of the accused when they were called. But PW2 did not say a single word about this Asmat Ali, your lordship, that he was present in my house, that when my father, along with some Asmat Ali, they went together, I followed them. About his presence, your lordship, absolutely nothing, your lordship. Now he says that he was present, he went with the deceased, and he saw the incident. Thereafter, he says that there was no any Bichar Sabha, there was no any gathering of persons. This has come in his cross, your lordship, that there were no any other person, there was no any Bichar Sabha, and the incident took place, your lordship. Now this is highly doubtful whether that PW3 was in fact went to the place of occurrence or not. And PW4, lordship, is the son of the deceased. He says that he was in the house. After hearing the incident, he went and then he saw. But if we see the sketch map, your lordship, there is a distance between the house of the informant, this house of the deceased, and the house of the accused, your lordship. After hearing Allah and cry, he went, your lordship. And then he said that he saw that the accused is giving a fatal blow, your lordship. That is quite improbable, because after giving the assault only, the Halla had started, your lordship. Sketch map, lordship, will find at page number 83. And he is also the son-in-law of the deceased. Accused Manul House is represented by GA Ga, and the deceased Jamaluddin by CHHI, your lordship. There is a road in between both the houses, your lordship. There is also, what is the distance, that is also being stated by one of the accused, I think. Now, this whole case rests on the deposition of this brother, the son-in-law, and one Asmat Ali, the PW3. Regarding his presence, your lordship, there is very high level of doubt, because about him nothing was said by other the son, your lordship, who said that he accompanied his father. After him, he went. But about this Asmat Ali, absolutely nothing was said. And Asmat Ali said that he did not find any bichars over there, no any person was there. So regarding his presence, your lordship, there is a question of doubt, your lordship. Now, apart from the fact that since there was a bichars, a large number of people were there, your lordship, but nobody else was being shown as a prosecutor. One were there, but they one turned hostile, and two others said that they have not seen the incident at all. So the accused giving the fatal blow to the deceased, your lordship, that has not been witnessed by anyone. That is being heard of. Except PW3, who states that he accompanied him, he was there with him. with the deceased at the time. But the PW2 did not say that PW3 accompanied my father. He was there with me. He was there with my father. To attract section 302, your lordship, there is the requirement of an intentional lordship. Now, as bamboo stick is used, your lordship, that generally bamboo sticks are found in the villages. It is quite available, your lordship. And a bamboo stick is used. And one, but it is not that several blows he had given. One blow was inflicted, your lordship. Now, with a bamboo stick, your lordship, in a open Vichar Sabha, your lordship, a person will commit murder of another person, your lordship. That is quite improbable, your lordship. My first submission is that the whole case rests on the interested witnesses. Although it is a fact that a Vichar Sabha was held, as many as 200 people, forget 50 people or 60 people were there at least. But not a single independent witness has supported the case of the prosecution. The whole case rests on their depositions. And then, your lordship, this bamboo stick that has not been recovered, that has not been seized, that has not been sent for FSL, that has not supported the case of the prosecution also, which bamboo stick, that would have given at least some clue. And then, your lordship, the way the incident is said to have been committed with the help of a bamboo stick, this case does not in any way come under section 302, your lordship. Because there must be a motive, there must be an intention. And the intention, your lordship, there is nothing on record to show that there was some previous rivalry or that they had any altercation. It is quite improbable that suddenly one person would go and one person will give a blow. That also in front of about 50, 60 or 100 persons, your lordship. And then there is not a single independent eyewitness, your lordship. The nature of assault, only one single blow. Had there been an intention, in your lordship, he would not only have given a fatal blow in the head, then he would have given some 3 other 4 blows to ensure that the person had seriously died. So that is, your lordship. The nature of assault is one single blow. The weapon used is a bamboo stick. This clearly shows that there is absolutely. And that bamboo stick was also not seized and recovered, your lordship. The most important, your lordship, why not a single independent eyewitness has come and deposed in favor of the prosecution story, your lordship? It's a case of murder in a Vichar Sabha, your lordship. Rests on the deposition of the interested witnesses, and not a single of them has specifically stated that they have witnessed the incident, your lordship. So the case has not been proved beyond reasonable doubt by the evidences that have been tendered before the learned trial court below. And lordship knows if there is any doubt, the benefit of doubt will definitely go to the accused, your lordship. In the section 313 CRPC said that he was not there. Subsequently, he came to the place of incident. He had denied. That there was a premeditation, that there was some intention, that he was intentionally called, then some dagger or something was used to kill. That is not absolutely there, your lordship. So in the absence of a premeditation, in the absence of a proper motive, your lordship, conviction under section 3202 cannot be sustained. More so, your lordship, when the whole case rests totally on the interested witnesses. 2-3 persons who have deposed as independent witnesses, they said that they have not seen the incident, your lordship.
How do you say that they are interested in this?
PW1 is the brother, your lordship. PW2 son, PW4 son-in-law, and PW3, your lordship. His presence itself is doubtful, your lordship.
Presence of PW3.
See, because he said that he was in the house of the deceased. Then both of them were together. They were called by the accused. That fact has not been stated by PW2, who is the son of the deceased. He said that he was also in the house His father was called, his father went and then he accompanied him. That his father was accompanied by another eyewitness, he would have specifically stated, had it been a case, your lordship, it is quite improbable that the son would not say that my father was accompanied by PW3 Asmat Ali at the time of incident. Why he would not say this thing? While the PW3's whole evidence is that I was there in the house of the deceased when we both of them were together called and we went together and I saw the incident. And then he said that there was no any Bichar Sabha. In the cross also he is stating that there is no any Bichar Sabha. If lordship wants to PW3, I'll read once again, your lordship, because he is the only independent witness.
All persons are related to a victim. Interested people.
Lordship,
Are all witnesses who are related to a victim, do they all become interested witnesses?
no, all do not become interested witnesses. But in this case, your lordship, why I am saying so, your lordship, if the incident would have occurred in a behind something, or that there are no other persons, yes, or nearby relatives have seen it has happened inside a small house, we are present. At that time, they will not become interested if their presence is shown. But if there is a large gathering of people, your lordship, and of only the interested witnesses come, then it becomes doubtful, your lordship. Suppose the incident, lordship, took place inside a house, and probability that my son is also there, they have seen it. In that case, your lordship may take an inference that though interested, but it is in all probability they would be there. But this is a case where a Bichar Sabha was going on. Admittedly, some people were there, 20, 25, 30, 40, 50, 60. But when no other witnesses are coming to support your lordship, if in a Bichar Sabha, at least 1 or 2% from the Bichar Sabha would have come and said that, yes, I have seen the incident. There is not a single independent witness. Therefore, what I am saying is that in the present case, they comes within the differential of interested witnesses. Because there are chances of other persons why they are not coming or why they have not been made a prosecution witness, your lordship. Otherwise, interested witnesses may also reliance can be made on the relatives also. If it is shown that no, they were present and there were nobody else, so they have witnessed the incident. But here is a case which took place in presence of a large gathering. Admittedly, in the affair also, and in deposition of all the witnesses, it has come that there was a village sabha or a Bichar Sabha was there. So, lordship, at least 1 or 2 independent witnesses ought to have been there, which would have cast 100% credibility to the prosecution story, your lordship. There is a case, your lordship, where they have deposed and only PW3 is saying, but his presence is highly doubtful, your lordship.
PW3 is not the only independent witness.
I have found him to be the only, he is a villager. He is a villager. But he is giving a story which is not supported by PW2. And in his cross, he is stating that there were no any persons in the, if the lordship goes to the cross last line, no other persons went there, nor was there any meeting held there. If a person went to Bichar Sabha, and if he says that no, there was no any other person, your lordship, then his presence itself is doubtful, your lordship. And the IO has in his cross admitted that they have made improvements which they have not stated before the IO, your lordship. Specifically PW3 also.
This Bichar Sabha was held in the house of the accused.
It seems that it is
in the house of the accused.
In the house of the accused or in the premises of in the courtyard, some courtyard.
Like I said, there are some figures which is about 200. In one place it says about 25, 30 people. And PW3 says there was nobody. Ordinarily, will somebody commit a crime in front of the Sabha?
Yes, that is also.
Large people are gathering there and you are there with a bamboo hitting somebody.
Hitting someone. Yes. He and Jamal, both of them were called. Yes. That is correct, but what he's saying that he was in the house of the deceased at the time of incident. Both of them are in the house of Jamaluddin and both of them are called together. They went together. Then this fact ought to have been told by PW2, the son, that my father was in my house with PW3 Asmat Ali. At that time, my father and Asmat Ali were called. They went together. I followed them. That the presence of Asmat Ali is not being confirmed by PW2, your lordship, the son, who was there in the house itself. PW3 is saying that I was in the house of the deceased. I went with the deceased.
Right, we'll assemble that. Promotional. Yes.
Lordship may consider the impugned judgment now. It starts from page 40.
You want your mic, isn't it? Not Page 40.
It's from page 40, but relevant page, I think Lordship may come to page number 50.
Yes. Para?
15.
15.
PW1 is the brother of the deceased and the informant. He proved the FIR by Exhibit 1 and also his signature by Exhibit 1:1. He also proved the inquest report by Exhibit 2 and his signature as Exhibit 2:1. In the FIR, he had categorically mentioned that it was the accused who assaulted his brother, the deceased, with a lathi on his head and he fell down. Thereafter, Asmat Ali took him to the hospital. He said Asmat, but I don't know, it has been taken to be Asmat Ali. Took him to the hospital where he was declared brought dead. This would go to show that PW3 was present at the time of occurrence and he is a vital witness. Where the learned court below has taken Asmat and Hasmut with the same person. I don't know whether it is, because there is nothing to show that Asmat and Hasmut are the one and the same person. Then you look paragraph 16. PW3 deposed that at about 6:37 p.m., Jalil, the brother of the accused, called the deceased to his house to settle a dispute between Jalil and the accused. At that time, PW3 was also there, and so he accompanied the deceased. And Jalal alias Jalaluddin, son of the deceased, went to the house of the accused. Seeing them, the accused asked as to why they had come to his house, and when the deceased asked him not to quarrel with his brother Jalil, the accused got furious and gave a blow on the head of the deceased with a bamboo lathi. He fell down, and PW3, along with Jalaluddin, PW2, Rustam Ali, PW4, and son-in-law of the deceased, took him to the civil hospital where he was declared brought dead. Now, the evidence of PW3 is supported by Jalaluddin. In my case is that the evidence of PW3 is not supported by PW2 because the presence of PW3 is nowhere being stated by PW2 at any stage. PW2 also deposed that a bichar was held in the house of the accused in the evening on the date of occurrence to where the deceased was invited. So the deceased went to the house of the accused and PW2 followed him. PW2 did not say that the deceased, that is his father and this Asmat went together. He did not mention about Asmat. When the deceased reached the house of the accused assaulted him with a bamboo lathi on his head. His father fell down, and at this moment, PW2 arrived there. After his father fell down, he arrived at the spot, and the accused fled away. He, along with Rustam and Ramzan, took his father to the hospital, where doctor declared him brought dead. From the evidence of PW2 and PW3, it is proved that when the deceased reached the house of the accused the accused, without any grave and sudden provocation, gave a blow on his head with a bamboo lathi. There was a bichar in his house on that day where the deceased went to interview a dispute between the accused and his brother. Therefore, it is crystal clear that there was no dispute or any kind of quarrel of the accused with the deceased. The deceased did not do anything to provoke the accused also, but the accused assaulted him on his head, which is a vital part of the body, with a lathi with such a force that his parietal bone got fractured as deposed by PW8, which is supported by Exhibit 2. In Exhibit 2, as well as in the evidence of PW8, it has been surfaced that blood was oozing out of the nose and ear of the deceased. This fact is supported by PW6, which would go to prove that PW6 was also present at the time of occurrence. But this fact is not supported by PW6. I'll take your lordship to PW6. In fact, he was PW6 lordship will find at page number 20. In fact, he was declared to be a hostile witness. He never said that he had seen any blood oozing out or something like that. PW6 is one Ramzan Ali. He said, I know the accused Mainul Haq. I know the informant Ramzan Ali too. I also know the deceased Jamaluddin. The deceased person is the elder brother of the informant. The incident took place about 3 years ago. In the evening of the incident, when I was returning home from the daily market, I heard a commotion at the house of accused Mainul. Then I went ahead and saw Jamal, who was injured, being brought by people from Mainul's house, holding him in support. I heard from the people that Mainul had assaulted Jamal. People fetched a tempo van and took him in that van to the hospital, but I heard that Jamal had died on the way before he reached the hospital. I did not witness the incident myself. I don't remember the day, the date and the time of incident. I was not in Goraimari daily market with accused person's elder brother Keramat Ali at the time of incident. The daily market is 1 kilometer away from my house. The place of incident is about 2 furlongs away from my house. I heard that the incident had taken place on Manul's land, the house of Ikramul, Tahir and Lalmiar on the east of Jamal's house. At the time of the incident, there was nobody in the west. Nur Islam's house is to the south. Nur Islam's house is across the road. Jamal is the son of Jalil's paternal uncle. Jalil's son Shahadat is not mentally fit. He beats up people and also bites. I heard from people that a fight had taken place in connection with Jalil's son Shahadat, and that is why Jamal died. He nowhere said anything about blood coming out or regarding his presence in the place of occurrence. But the learned trial court has made an observation at page 52, just at the end of paragraph number 18, that PW6 was present at the time of occurrence, and he has also corroborated the statements of PW2 and PW3, which is totally otherwise not correct, your lord.
No, here it's written. I was returning from the daily market. I heard commotion at the house of used to be my Then I went ahead and saw Jamal, who was injured, being brought by people from Bangalore. So he saw Jamal.
No, after the incident.
Injured condition.
In injured condition, after the incident.
Yeah.
I'll read again,
So
your
it
lordship.
says PW6 was also present at the time of the occurrence.
Not at the time, after the occurrence, it may be said, your
So
lordship.
basically after the occurrence.
After the occurrence.
He saw the blood.
But I will read again. But the accused assaulted him on his head, which is a vital part of the body, with a lathi with such a force that his parietal bone got fractured, as deposed by PW8, which is supported by Exhibit 2. In Exhibit 2, as well as in the evidence of PW8, it has been surfaced that blood was oozing out from the nose and ear of the deceased. This fact is supported by PW6, which would go to prove that PW6 was also present at the time of occurrence. Besides, both PW2 and PW3 deposed that the accused hit the deceased on his head, which is supported by medical evidence. The evidence of both PW2 and PW3 is not shaken during their cross-examinations.
PW8 is the doctor who did the PME.
PW8 is a doctor.
So discovery is that bleeding from nose, right ear present,
Yes, yes.
fractured.
Yes, yes. That is,
So
that is there.
that is what is describing here. Parental bone got fractured as deposed by PW.
Yes, it is correct.
By exhibit 2. Exhibit 2 is the PME report.
PM report.
Yes.
Mr. Vaishnava has submitted that there are discrepancies in the evidence of both PW2 and PW3, such as PW2 did not state before the police that the accused fled away after committing the offense. The occurrence took place at 6:30 p.m., etc. And PW3 did not state before the police that he was present in the house of the deceased, and then Jalil called the deceased to his house to intervene in a quarrel with the accused. Both of them went to his house, and when the accused asked the deceased as to why he had come to his house, and the deceased in reply asked the accused as to why he was quarreling with his brother, as deposed by PW2 and PW3 during their cross-examinations. He has submitted that such discrepancies have made the testimonies of PW2 and 3 unreliable, more so when PW2 is a related witness. This court has gone through the statements of PW2 and 3 recorded under section 161 CRPC. Both PW2 and 3 describe the relevant facts such as their presence in the place and time of occurrence, as well as seeing the accused assaulting the deceased on his head by a bamboo lathi. Therefore, the discrepancies referred by Mr. Vaishnav are not relevant and do not shake the very backbone of the prosecution story. Besides, it is well settled that all discrepancies in the statement of the witnesses made before the police as well as in the court are not fatal for the prosecution if the same does not shake the very backbone of the prosecution case. Now, the judgment has been cited, Your Lordship. Gurbachan Singh judgment. To show that minor contradictions do not
consistency,
if otherwise consistent in my Lordship. Then paragraph 23. As has already been discussed from the evidence of PW1, PW2, and PW3, it appears that PW4 was also present at the time of at the place of occurrence. The court is of the way it appears, means court is in a presumption, taking a presumptive plea. It appears that PW4 was also present at the place of occurrence. PW4 had deposed that at about 6:30 p.m. on the date of occurrence, he was present in the house of the deceased. Then he heard hue and cry in the house of the accused, and PW4 went to his house. When he arrived at the house of the accused, he saw the accused giving blow on the head of the deceased with a bamboo lathi. On being so assaulted, the deceased fell down on the ground and he sustained injury on his head. He had further deposed that he saw blood oozing out from the ears, nose, and head of the deceased. At that time, many people gathered there, and he, along with PW3, took the deceased to Nagaon Civil Hospital in a tempo, but he was declared brought dead. From the evidence of PW4 also, it is seen that this witness has also seen the accused giving a blow on the head of the deceased with a bamboo lathi. He is the son-in-law of the deceased and is stated before the police exactly in the same manner as he deposed in the court. In his cross-examination, he denied the suggestion made to him that he did not state before the police that he saw blood oozing out from the head, ears, and nose of the deceased. His evidence is supported by medical evidence for which a confidence is reposed on the testimony of this witness. The remaining part of his cross-examination is not material, since those relate to only some general queries regarding the neighbors of the accused, their houses, the distances among the houses, and as to how many people gathered about after the occurrence, etc. From the evidence of PW2, PW3, and PW4, it is proved beyond reasonable doubt that it was the accused who assaulted the deceased on his head with a bamboo lathi, as a result of which the deceased fell down on the ground and died instantly. All the aforesaid three witnesses deposed similarly, and it is proved that they were present at the place of occurrence and had seen the occurrence. PW2, PW3, and PW4 have deposed without any material alteration or improvement from their earlier statement made before the police, for which their evidence can be relied on. Although Mr. Vaishnav has submitted that the witnesses are relative of the deceased, and hence their evidence cannot be relied upon to base a conviction, this court does not agree with the said submission made by Mr. Vaishnav. And thereafter, reliance was placed. So the learned court below basically relied on three witnesses, the PW2, the son, the PW31 Asmat Ali, and PW4, the son-in-law of the deceased Rustam. Now, Lordship has gone through the statement of PW2, Your Lordship. He said that he followed his father, and immediately after the incident, he reached. By that time, the accused had already fled. This is their, Your Lordship. He did not say absolutely a single word about this PW3 Asmat Ali, that Asmat Ali was accompanying my father, that they were both present, which fact is stated by Asmat Ali, Your Lordship. Asmat Ali's statement, I'll take Your Lordship once again for a moment of deposition of PW, because that is very important, Your Lordship. PW2 did not utter, PW3 and 2 and PW4 also. He also did not say that Asmat Ali was there in the house and he accompanied the PW, the deceased. I'll read the statement of PW3 once again for a moment, Your Lordship, at page number 1313. Just from the, I know the accused so and so, I know Ramzan Ali, he also belongs to me, I also know him. The occurrence took place in the year 2012 at about 6:37 p.m. At the time of occurrence, I was present in the house of the deceased Jamaluddin. This is important. He is saying that at the time of occurrence, he was there in the house of the Jamaluddin, the deceased person. Just then, the elder brother of the accused, namely one Jalil, called on me and Jamaluddin to their house. Thus, the accused person had called him and Jamaluddin that you come to our house to make an intervention regarding dispute occurring among their brothers. Accordingly, I, along with Jamaluddin and son of Jamaluddin, namely Jalal, went to the house of the accused person. He said that I, along with Jamaluddin and also the son. But when the son deposed as PW2, Your Lordship, he is totally silent about this Asmat Ali. He did not say a single word, Your Lordship, while Asmat Ali is saying that he was present in the house of the Jamaluddin and he accompanied Jamaluddin, Your Lordship. Even PW4, the son-in-law, he also said that I was present in the house of the deceased, but he also did not say that this Asmat Ali was accompanying the Jamaluddin while going to the when they were being called upon by the accused. And in the cross also, Your Lordship, he has said that he did not find any person there. There was no any bichar, nothing, Your Lordship. Therefore, his presence at the time of occurrence, Lordship, only on his statement cannot be taken to be conclusive proof, Your Lordship. When he is not being supported by PW2, the other witness, the son, and PW4 also, he also did not say. PW4, Lordship, I'll just read PW4 for a moment. He said that he was also present in the house of the deceased. I'll read this PW4 for a moment, Your Lordship. At page 16, Your Lordship. I know the accused person standing in the dock. His name is Manul Haq, who is my paternal uncle. I know the informant Ramzan Ali. The deceased Jamaluddin was the elder brother of informant Ramzan Ali. The occurrence took place at about 6:30 p.m. of the evening. On the date of occurrence, at the time of occurrence, I was present in the house of accused deceased Jamaluddin. He's saying that he was also present at the house of Jamaluddin. He also did not say a single word about that Asmat Ali was also present. Just then I heard somebody raising halla in the nearby house of the Manul. Then I rushed to the house of Manul. While I reached the house of Manul, I saw Manul giving a blow on the head of Jamal Bhai Bambulati. Now, this PW4, he also did not say a single word, Your Lordship, that Asmat Ali was there with the deceased, and both of them went there. I was also there in the house. So this casts a very doubt about the versions given by PW3, Your Lordship, that he accompanied the deceased at the time of the incident and he saw the incident, Your Lordship.
Otherwise, PW4 is eyewitness.
He claims to be eyewitness. Now, Your Lordship, regarding PW4, I'll submit. PW2 is the son, Your Lordship. Now, he said that immediately after his father went, he followed. He found that already his father was lying and that this accused had fled away. So if he followed his father and then also he could not go and see the incident, then PW4, Lordship, he went after hearing the halla, Your Lordship. It is totally improbable that after going there, he would still find that he was beating and he had seen the incident, Your Lordship. PW2, he said that he just followed his father. And thereafter, he said that after reaching also, he could not say. I'll read PW2 for a moment again, once again, Your Lordship. From the fifth line, the occurrence took place about 6:30 p.m. of the evening. On the date of occurrence at evening hours, a bichar was held in the house of Manul and my father was called on to appear in that bichar. Accordingly, my father went to the bichar in the house of accused Manul. He did not say anything about Asmat Ali. I also went after my father to the house of Manul. He followed his father. When my father arrived at the courtyard of Manul, he attacked my father there and assaulted on the head of my father with a lathi made bamboo. And as a result, my father fell down on the ground. Just then, I arrived at the spot. This is very important, Your Lordship. And accused Manul fled away therefrom. Now, what he says that he followed his father, but by the time he reached, at that time, Manul had already fled away. And what PW4 is saying, Your Lordship, that he heard Halla and then he went and then he could go and see the incident, Your Lordship. This is totally improbable. Just to make out a case, Your Lordship, he is saying that he went and see the incident, Your Lordship. He is also a related witness, Your Lordship. If PW2, he had followed his father and he could not see the incident, he said that immediately after the incident, just then I arrived at the spot. He did not see the incident even after following. But PW4 said that he heard Halla, he then went and then he found, Your Lordship. And from the sketch map, Lordship will find there is a distance, Your Lordship. It is not possible that immediately he will go and he will wait to see the incident, Your Lordship. So now all the three witnesses are 3 and 4 are related witnesses. I'll not say interested, they are related witnesses. And regarding the existence of PW3, there is high doubt because PW4 as well as PW2 did not say a single word about the presence of PW3, Your Lordship. PW3 said that he was in the house, he accompanied the deceased, but PW2 son, he did not say that my father was being accompanied with PW3 who was in our house. Therefore, his presence is highly doubtful, Your Lordship. And in the absence of
PW3.
3 is highly doubtful. PW2 did not see the incident. He is admitted that just after the incident, he reached the spot. And PW4 said that he saw the incident, but it is totally improbable because after hearing the Halla, he went, Your Lordship. Halla started only when the fight already taken place, Your Lordship. So in the absence of corroboration from some other independent witness, which are likely because of the presence of a Gram Sabha, Your Lordship, large number of people, Your Lordship, reliance solely on PW2, PW3 and PW4, Your Lordship, the conviction cannot be sustained, Your Lordship. And other things I have showed that only a bamboo stick was used, Your Lordship has seen. And it is allegation is that in the affair, it was a different story, completely different story that both the brothers called him one court told.
You're saying only a bamboo stick.
Not. No, it can cause death, Your Lordship. But
bamboo is one kind of plant. It's very good. People make tofa out of it, make houses. What do we use this? There are varieties of bamboos though. And one flow is otherwise something. You hit
Yes.
the right spot.
Yes, it is
Don't
sufficient.
hit the person. Never know. The nature of injuries are there. So that one hit is there.
Yes, one hit.
What has happened? What the plate fractured? Supposing we discard PW3, what happened?
Then remains PW1, 2, Your Lordship.
2 and 4.
2 and 4. 2, admittedly, he said that after the incident, he reached. Just then means once the incident occurred, he reached. By that time, Manul had fled away from the spot.
All these depositions are recorded in English and not vertical, English. There's no translation.
Nowadays, most of them are in English only. But these depositions were of 2000.
Problem is, English is not our mother tongue. So you want to express something and sometimes you end up expressing something else. Yes, what else?
Well, just statement judgment that
Judgment
on
on what?
on this point that if there is doubt regarding the presence of interested or related witnesses, at that time corroboration should be sought for from other independent witnesses if they are available, Your Lordship. My case is that these three persons have not witnessed the incident. But regarding PW3 lordship, his presence is quite doubtful because his presence has not been stated by PW4 as well as PW2, your lordship.
I think that is your main point. You have been repeating that.
Yes,
again
and PW2 also he did not see the incident. And PW4 also there is no probability that he would go and see the incident because after hearing hue and cry he went. And then he said that he had seen the incident. While PW2 he was said that he accompanied his father. Then also by the time he reached he found that the incident already occurred, your lordship. So in that case, when there were possibility of independent witnesses, why no other without corroboration from some independent witness, your lordship, relying solely on PW2 and PW4 is not safe, your lordship.
But the trial court has also given some
Lordship.
reasoning
Given.
why that we rely upon.
The trial court has admitted the evidence of PW3, which we are saying that his evidence cannot be admitted in the absence of corroboration from
Paragraph 26, 27.
lordship. May I read your lordship?
Court has to be careful.
Yes, yes. May I read your?
Yes.
It is no more res integra that the evidence of a later witness can be relied upon base a conviction, but the court is to be careful in appreciating such evidences. In so and so, your lordship, Honorable Supreme Court in paragraph 20 of the judgment observed that merely because the witnesses are related to the complainant or the deceased, their evidence cannot be thrown out if found to be consistent and true. Such relationship is not a factor to affect the credibility of a witness, and the courts have to scrutinize their evidence meticulously with a little care. Similar view was adopted earlier in so and so. So only because PW1, 2, and 4 are related to the disease, their evidence cannot be thrown out. And the evidence is corroborated by independent witness PW3 also who had seen the occurrence. So their statement in corroboration with PW3, your lordship, the court has come to a conclusion, your lordship. But my case is that, your lordship, this presence of PW3 is totally doubtful in the absence of corroboration from PW2 and PW4, your lordship. And the prosecution must prove the case beyond reasonable doubt, lordship knows. And if there is any doubt, your lordship, whatsoever, the benefit of doubts will definitely go to the accused, your lordship. And in a Vichar Shobha, suddenly he was killed with
What about the delay part? FIR?
Yes, FIR, there is a delay, your lordship, of 2 days. This is quite improbable, your lordship, because if suddenly a fight took place and nobody knows what happened, your lordship, at that time, FIR might have been filed belatedly. But this is a case where they said that this person specifically killed my brother. They went to the civil hospital, and by the side of the civil hospital itself, there was the police station. It has common evidence. But they did not lodge the FIR, your lordship. There was a delay of 2 days, your lordship, in filing the FIR. And the FIR story is totally different from the prosecution story. FIR story, what he has said is that both the brothers called them. One brother caught hold of him, and the other brother made a fatal blow. If lordship remembers the FIR, he was not there. Yes, not there. Yes, 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 yes. Yes. Even I don't know what is there in there. Yes. He was brother. By It would not have mattered, your lordship, had it. Now he had given a completely new version of facts in the FIR. Within 2 days, he could have come to know what had happened. Suppose immediately if I go and lodge an FIR, I have heard something and I have lodged an FIR. But after 2 days, he is going with an FIR. By 2 days, he must have known what has happened, what has not happened. How he has implicated the another brother with saying that both of them got. Not, and therefore I am not onto that. Yes, it's already there. Yes, I have also. What I am just showing that he tried to implicate both the brothers. Somehow one brother is now safe, but other brother is under the scenario. Yes, it's not as one of the witnesses has said, yes, yes. The case stands only on PW2 and PW4, your lordship.
Do you have any decision regarding the interested witnesses?
One decision, just one decision. Otherwise, there is no problem relying on the decision of interested witnesses if they are totally. The court is of the view that not they are accurate and there is no any doubt. But if there is a doubt, your lordship, at that time corroboration is required, your lordship. That is what.
Court does have any doubt?
Yes, trial court did not raise.
Any doubt?
Did-
They have later in the first. Only thing is that one has to be careful. Trial court again put the name of the PW3.
PW, he is heavily relied on PW3 to base conviction on the deposition of.
Say PW3 cannot be relied upon.
Cannot be relied upon because
Others have not mentioned this.
absolutely not, your lordship. This is very important, your lordship. He-
Just an omission. Omission.
Now, omission from one person, okay, but from both the persons who were present, who were members of the family. This is quite doubt. He said that he was in the house of the deceased and he accompanied the deceased. This fact has not been stated by PW2, your lordship. Though he said that I followed my father. Yes, yes, yes.
They will take the name of one particular.
No, they are not, they are related witnesses. They cannot be termed as interested witnesses. They are not related witnesses. No, just
Interest has to be on the outcome of the case, not because they are related to someone.
yes. Now that is
There is a case where a man has been hit on the head with axe. The son says, I saw this man hitting him. There was some altercation, he hit, I reached, he fled. Other witness says, this is the sentence he said, and then he hit, and then he fled. Next witness says, I saw it. Each witnesses, what interest they have in the conviction of this particular person when even the vichar which is taking place or that altercation which was the result. The original vichar is not between these two men. It is between two brothers. One of whose son being mentally unstable attacked the other one and they were supposed to be a vichar. This man goes because someone told him. He says in our family what kind of a vichar will you have? One strike and what interested?
not interested, but it is a case of related witnesses. Now, whether they have seen the incident, that is
a different issue. But the difference you are trying, but the fact you are trying to bring on by calling them interested.
I am saying related witnesses because not any other independent witness has been examined. This is also important, your lordship.
they are not interested. They don't need to-
Not interested, but related witnesses, Your Lordship, related by blood. No, if
Nobody.
they are not, but if
They're not interested. Other independent. They become independent.
because their presence, they have seen the incident that has not been properly proved, Your Lordship, that they have seen the incident. Lordship,
If they have not been in the.
before, but PW2, no, P2 is also saying that after the incident he reached. PW2, just then I have reached, Your Lordship. This is,
He
there.
says, it was there, my father fell down, I then reached the stop.
I
When
then-
my father fell.
Yes, yes, when his
So
father,
it could have been a distance of 20 feet. By the time I reached the 20 feet, he runs.
that may not be Your Lordship. Just then,
After.
just then I reached, Your Lordship. Just then I reached. Because he was following him. So they have not gone at the same time, but afterwards he had reached, Your Lordship.
I also went with my father, after my father,
Lordship,
after he with some distance,
Lordship.
not necessarily in the after the.
No, not after the,
While my father arrived at the courtyard, he attacked my father. And assaulted on the head of my father.
just then I arrived at the spot. Lordship, this is very
Then he arrives at the spot where the hit took place.
no, if Lordship,
Taking here and there in the different.
That is why I said in the beginning that English is not our mother tongue.
may not be, but we have to rely
And
on the depositions itself, Your Lordship.
position, that's why you're trying to interpret it in your own way.
Lordship,
It can be very well be interpreted in the other way also.
Lordship. If there is any sort of doubt, Your Lordship, benefit should go to the accused, Your Lordship.
The moment he reached there, he saw and he hit and he ran away. How do you know that he had not seen it? You're trying to say that the moment he reached, he had run away. So he did not see anything. It could be the other way around.
It could be, Your Lordship. Therefore, there is a doubt, Your Lordship. It could be, Your Lordship. Lordship is correct. It could be. Since
So you'll create a doubt and you'll create two views, and the view which is
in favor of,
favorable to the accused person should be utilized.
this is what the criminal law says about. Even otherwise, in this judgment at paragraph 9, I'll just rely, Your Lordship, that I have
We
given.
are aware of that.
With Peter, I saw many.
No. He said that he heard Allah and then he went to the spot, Your Lordship. He did not say that I accompanied them because as per the version of PW3, PW2 also, on reaching the spot, he was being hit. So if a person heard the Allah and then reached, Your Lordship, then there cannot be a chance that he would go and see the incident, Your Lordship. What PW2 says that on reaching the spot, he made a blow and he died, Your Lordship.
These are two different things. He heard Allah, I went there.
Yes,
The reason he went there was because he heard Allah.
Allah.
On reaching there, he saw the so-and-so giving a blow on the head of Jamal.
That time is not there, Your Lordship. From the evidence of PW2 also. PW2 shows that I accompanied my father. By the time he reached, Your Lordship, by that time the incident had occurred. And this evidence, he said that he was in the house. After hearing Allah, he went out and then he go and he saw the incident, Your Lordship. Therefore, what I am saying is that there is a requirement from an independent witness, Your Lordship. Otherwise, there is no problem with relying on the related witnesses. But when, Your Lordship, their presence is doubtful, Your Lordship, and when there were ample independent witnesses, Your Lordship, in the absence of corroboration, there is a doubt, Your Lordship. And that is what this judgment says, Your Lordship, for a moment, paragraph 9.
So once you say ample of witnesses,
Yes, it was a bichar sabha, Your Lordship.
correct, but has any other names been given in the chart sheet? That these are the 10, 15, 20 people who are there.
Some 3-4 other witnesses were there.
How many were named in the chart sheet?
Chart sheet 10 witnesses.
10 witnesses. So all of 10 of them have been examined.
Yes, there were 1 to 3 independent, but they did not support the case, Your Lordship. Nobody had seen the incident. How come it is possible? Everybody went there after hearing the Halla, Your Lordship. Every other witness stated that they have reached after. On hearing Halla, they reached and they found that he was lying on the courtyard.
All right, you sum up.
Lordship.
Yeah.
So, just I will read the paragraph 9, Your Lordship.
Paragraph 9 of
This judgment that I have read. Non-examination of independent witnesses by itself may not give rise to adverse inference against the prosecution. However, when the evidence of the alleged eyewitnesses raises serious doubts on the point of their presence at the time of actual occurrence, the unexplained omission to examine the independent witness so and so would assume significance. Now, the judgment has been proved, Your Lordship. If already overwhelming evidence is available, an examination of other witnesses would only be a repetition or duplication of the evidence already adduced. Non-examination of such other witnesses may not be material. In such a case, the court ought to scrutinize the worth of the evidence adduced. The courts of fact must ask itself whether in the facts and circumstances of the case it was necessary to examine such other witness, and if so, whether such witness was available to be examined and yet was being withheld from the court. If the answer be positive, then only a question of drawing an adverse inference may arise. If the witnesses already examined are reliable and testimony coming from their mouth is unimpeachable, the court can safely act upon it, uninfluenced by the factum of non-examination by the witnesses. In the present case, we find that there are at least 5 witnesses whose presence at the place of incident and whose having seen the incident cannot be doubted. It is not even suggested by the defense that they were not present at the place of incident, did not participate therein. So, if there is no doubt, Your Lordship, if the court is of the view that it is unimpeachable and they have seen the incident and this has happened like this, there is no requirement. But I am saying that their presence is doubtful, they have not seen the incident. And therefore, at least one corroboration should have been there to rely to base conviction, Your Lordship. And if still Your Lordship feels that no, this is a case of murder, Your Lordship, with the intention, Your Lordship, then I'll just place one judgment, Your Lordship. But the court has said that my case is that there are doubts and the benefits of doubt should go to the accused, Your Lordship. Secondly, Your Lordship, in order to attract section 302, there should be an intention, Your Lordship. That intention has to be find out that yes, there was some previous rivalry or that something was there. There was a premeditation. He was called, a dagger was used and that took place, Your Lordship. But this is a case, Your Lordship. He went there, there was a bamboo stick. He made a single blow. Allegedly, he made a single blow and he died on the spot. So whether this provision can attract section 302 IPC, Your Lordship. Now, this decision that I have given, Your Lordship.
Are you suggesting that it would very well be 304?
If Lordship finds that no case has been proved beyond reasonable doubt, Your Lordship, then Your Lordship, it will be a case under section 304 part 1, Your Lordship.
Which para?
Lordship, paragraph 15. Just reading a lot. I have a sub copy. Para 14. Can from 15 we can read, Your Lordship. May I read, Your Lordship?
Yes.
From the testimony of so and so PW 6 itself, it will be clear that after a scuffle took place at the house of Rajendra Bosale, the accused appellant went from there and the deceased followed him. Thereafter, as to how the assault took place is not clear either from the evidence of so and so or from the evidence of so and so. It is, however, clear that after the accused appellant left the place, the deceased followed him. After that, as to what had happened between the deceased and the appellant is not clear from the evidence from the eyewitnesses. From the evidence of so and so itself, it is clear that the deceased had nothing to do with the incident. The appellant had come to the house of so and so where she and her husband had gone. Rajendra Bosale had gone to answer nature's calls, and 3 of them, that is the deceased, Sunita Bosale and Chaya, the wife of the Rajendra Bosale, were present there. The appellant started abusing Rajendra Bosale and his wife Chaya. The deceased intervened and asked the appellant as to why he was abusing Rajendra Bosale. Irked by the intervention of the deceased, the appellant started abusing the deceased and thereafter went away. It is thus clear that no motive has come on record as to why the appellant wanted to commit the murder of the deceased. The evidence of the eyewitnesses also does not show that the appellant had come with any weapon. On the contrary, the medical evidence would show that the injuries caused are with the bamboo stick, which is commonly available in a village. The possibility of the deceased following the appellant and an altercation taking place between them and in a sudden fight in the heat of passion, the appellant assaulting the deceased cannot be ruled out. As already discussed herein above, the prosecution has utterly failed to prove any case of premeditation. On the contrary, the case as put further by the prosecution is about the appellant coming to the house of so-and-so, abusing his wife so-and-so, and the weapon used is a bamboo stick which is commonly available anywhere in the village. The nature of the injuries sustained by the deceased would also not show that the appellant had taken any undue advantage or acted in a cruel or unusual manner. In that view of the matter, we find that the appellant is entitled to benefit of doubt. The conviction of the appellant under section 302 deserves to be altered to one under part 1 of section 304 IPC. Here is also a case, absolutely nothing has been showed that there was any previous rivalry, that he had decided to kill that person. He had made up a plan, called him there, and then and then committed the murder, your lordship. It was a village gathering, large number of people gathered, your lordship, and it is quite improbable that a person would call a person to murder in front of such a huge gathering, your lordship. But my case basically is that, your lordship, the prosecution has failed to prove the case. Nobody has seen the deceased making the fatal blow, and therefore, your lordship, in the absence of corroboration from at least one independent witness, your lordship, conviction cannot be based on the highest. The one line, your lordship.
There were 3 types of injury possible.
3 types.
What is Allah?
Noise.
Noise. It is not the act of, like beating. It's Allah means a noise. Quarrel. So precisely that Allah happened after the fight, before the fight. Prior. Prior to the assault. Allah did not happen after the assault. Which quarrel is we might be referring to, you say? Yeah. Yes. Yes, yes. What do you mean motive is not necessary? There was a halla. There was a quarrel. The heat of the moment it was. What is the reason behind the spiking of the? No previous enmity, no motive, not premeditated, no planning. IPC. It says if it is done in the intention of causing bodily harm, injury to any person, and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Well, was fine. Must have been a reasonably sized bamboo, isn't it? How has it been explained? Because of autopsy and burial of deceased. Which judgment is that? How many days delay was there? All right, we'll find out. Go to the next. Which one is regarding delay? Okay. Delay was for 1 year. Yeah. Was delay, brother. 1 year. We're talking about 2 days here. This is what regarding impressive witness. Related witness. Please write down. Heard Mr. M.H. Lashkar, learned amicus curiae for the appellant. And Mr. R.R. Kaushik, learned additional PPHR. The learned counsels have made their submissions. Hearings concluded. Will require two, 3, and 4, isn't it? But was it kept as a part? Yes. Nothing about. If I but yeah. To recapitulate everything. Start from the beginning. I think this division bench, special division bench will go on next week. Next week. Difficulties there. I don't know whether you've seen the roster. This special division bench continues next week. Next week. Then 2 weeks thereafter, I'm off. Otherwise, also the first contact. Then the vacation starts. The summer. It'll be better to having reopening. Time is very short. And I continue throughout this month, different thing. Hope is reopening on. Basically, all these criminal matters are hearing matters. It takes the entire thing. No, this 15 to 26 I'm out. 2 weeks. And the break there. 2 weeks. Perhaps. That is one option. The other option is we have the release for part time. Then release it for part time. So that you take your time. No, I've heard it, but I've forgotten everything. We'll have to begin from the beginning again. So same effort. Only part is that delay will be there. That's why. For your benefit.
agree with this. Because government is also say something. Rules are a stick. That case, I'll not fix a date. I'll not fix a date. I'll say that whenever this bench is available after the vacation. On a hearing date. Is right as agreed to by the parties, this matter. After the incident, some occasion. On any hearing date. Which should be fixed by the registry. And when this bench is available. Yeah, you make a mention. Parties are also at liberty to make a mention. For listening when this bench. For listening the matter as and when it is. This is item 234.
May I please your lordship, in item number 10, my lord, similar prayer, my lord, item number 10. When the bench is available.
Item 10, I don't know why it's been listed as further hearing. Did we start?
Yes. It will be hard. My lord, from the petitioner side, my lord.
More than 1 hour.
Yes.
Now I'll hear more than 2 hours. Okay, similar order.
Similar order, my lord.
It's up to the parties. I'm not saying that it should stick to this bench. You can have your freedom of having this matter.
I mean, it will be hard by my lordship, my lord.
Are you sure?
Yes, my lord, you have been hard by lordship. My senior.
Okay. Similar order.
Highly obliged, my lord.
May I please, your lordship? So in item number 9, lordship, I want to file affidavit in reply. Lordship, some time may be given.
9 is coming with other
5 to
cases.
9, lordship.
5 to 9 are together.
Yes, lordship.
They are all sticking together.
Yes.
You want to file affidavit?
Yes, lordship.
You are 40?
Petitioner, lordship, review petitioner.
What affidavit you want to file?
Lordship, the last time they filed a reply, opposition, lordship. Regarding this affidavit in opposition, I want to file a reply.
What are these matters about?
Regarding lordship, in charge principal, appointment of in charge principal, lordship.
These are not part heard.
No, lordship, not part of review.
Your good name?
PZ Dutta.
Mr. PJ Dutta, on it, for the review petition. Review petition number 77 of 2023. Raised for and is granted. Which side?
Lordship.
File rejoinder affidavit. To the affidavit of position filed by the principal. Let's begin after 2 weeks.
Published.
Along with the other matters.
Okay.
You had filed a third party appeal.
I thought the third party, that's what
Remanded back. And you have been pleaded as the respondent number 7. Have you filed your counter affidavit?
Yes.
When? It's been 5. Now, who is for the petitioner here?
Your Lordship, the engaged counsel is on his way. Barbara sir is not present today, but the engaged counsel M. Smith is coming, is on the way.
M. Smith?
Yes, Your Lordship.
We'll fix it for hearing then. Rule has been issued or not? Not yet.
What happened? The order has been cut. How long still take them for it?
So what would you want? You want the matter to remain in the admission column or you want it for regular hearing?
75 my lord, I have the next one.
My lord, before my directed proceeds, my lord.
Take your time, take your time. We are not in a hurry, Mr. Counsel.
No, my lord,
Don't lose your breath like that.
Starting my lord, I have just clarify.
It's only clarifying.
yes.
That's the part one. That's what my lord. Because it has been assigned to your lord
Yes.
by the.
Is it so? Where's that one?
This,
Maybe they are by. Has been assigned
Oh.
to your lordship. That's why my lord. Cannot be different.
Perhaps because this bench was dealing with that bench two matter. That is why it came now.
There is small issue, man. That to be like from challenge. At that point. Followed by the guidelines by law, days by law, and like that. Only that is the point.
it can be adjudicated upon, my lord, that part, yes. And only at this point, my lord, they have filed the affidavit in opposition. And in the meantime, my lord, everything is ready. The petitioner, she was in Hyderabad for her husband's treatment. She has recently come back. We'll file our reply to the affidavit by this. Madam, any date we fix, we're not shying away from hearing. my lord. Any date, next week. We'll file within this week. The reply. Yes.
Then, they elaborate hearing and they are my lord. But my lord, that in my.
So one thing.
Lots of series
does it
has
have to
happened.
be with before this bench only.
Yes,
My lord,
yes, but. Lord, allow me to see that.
I've seen it.
Has to be your, by your lordship.
I've seen it. So it's a sign. So so why I was saying is that maybe because this court was dealing with bench two.
maybe.
That is why I was assigned.
My lord, please, what, my lord.
My lord, reply.
How much time? 1 week.
A week, same one.
1 week time.
Why I am worried, my lord, my salary, everything has been stopped. I got one. Is that,
No, this will come after the vacation day. They want 1 week. So we have only 1 week. Because why I'm saying is that because Mr. Gogo is right. I'll not be here from 15 to 26. About 30.
In the meantime, we'll file our reply. Before the exit fix, we'll file our reply. We'll not.
His right parties are represented by the respective counsel. Now, Mr. Jaya Bogoya, Learned Counsel for the newly impeded respondent number 7 submits that counter affidavit has already been filed by the respondent number 7. Now, Mr. M. Smith, Learned Counsel for the petitioner, submit that you would like to file a rejoinder affidavit. to the said counter affidavit and for which he prays for a week's time.
Perhaps the affidavit of the government is also necessary for proper education. That was when in the earlier petition. If at all they wishes, will it, but we'll file a reply.
Considering the same, list the matter after the no registry fix. There is a reason behind. List the matter again after the ensuing sum of the pay, as and when this bench is available, preferably in the on a hearing date, which should be fixed by the registrar. The parties are also at liberty to make a mention for listening of the case, as and when this bench is available. Then this direction has been passed in view of the order passed by the Honorable Chief Justice on the administrative side, that the matter should be listed before the hearing. That will be there. Because why I'm doing all this? Because see, vacation is there. Immediately after vacation, supposing this court is not there and I fix the matter, again we'll go. So now they will know when to fix it. When this bench is there, they'll fix it on the hearing.